Hey, everybody. Hey, James. Um, yeah, no problem. Hey, everybody. Hey, James. Um, yeah. Yeah, I'm fully expecting this to be a train wreck. Hopefully a fun one, though. Yeah, it is kind of early. Oh, yeah, I am a little early. I think I'm gonna have to go more with, Stop Cop City today, just because, I don't know, it's funny. Hmm. Hey, Lexi, Ashley. Can everybody hear me okay? So yeah, I think today's mostly going to be Stop Cop City. I tried to listen to the Gregory King case, and the sound just wasn't. It was hard to hear. I'm going to try to see if I can find like a clearer version for tomorrow or Wednesday, so we can go over that because that case is wild. Based on what I've heard from asking around, there's video that pretty much exonerates King completely. That's I haven't seen it, so I can't say firsthand. But we have plenty of video for Stop Cop City, for better or for worse. I'm gonna have to pull it up here just so we can go through it. I haven't really seen that much of it. Oh, there's 11 a live stream. I haven't seen this.
Did not provide evidence in support of that, which is similar to what we're at this point looking at.
Maybe we can start with this stream. 11 Alive has a stream. I was watching the Atlanta. Is that the Massachusetts case with Scapicchio? No, I don't know that case. Are you talking about that? I saw that cop that was Matthew says that the MA case was Scapicchio. No, I don't know that one. I'm behind on Karen Reed. I just get too many insane people trying to insult me and hurt my feelings. Anytime I talk about the case, Julie Carpenter, I don't know. She said some incoherent stuff. I can't handle that anymore. As much as
11 Alive Plus,
Julie
streaming
Carpenter.
live local weather 24/7. Check the radar whenever you want. Catch detailed weather updates.
Julie Carpenter. I'm sure gonna miss her.
In May of 2020.
Man, I was looking for a good Stop Cop City RICO stream, and I thought I saw one, but it was just my own stream. That was disappointing. Okay, I think I'm gonna try this version here after I skim through this indictment. Actually, I should tweet about myself going live first. Oh, thanks, Lexi. You tweeted about it. I appreciate that. Okay, so this is the Stop Cop City RICO. Actually, I want to pull up a little news article. Maybe that'll have some background. Yeah, I think this should work better. Work. Why aren't you working? Here we go. So that's just a random news article that I found. These are defendants. Single mother Priscilla Grimm lost her job. Aspiring writer Julia Dupuy frequently stares at the bedroom ceiling numb. Same Julia. Geography and environmental studies researcher Hannah Cass is worried about her career prospects after she graduates from her PhD program. The three are among 61 defendants accused by Republican Georgia Attorney General Chris Carr, who was formerly the Fulton DA, of participating in a years-long racketing conspiracy to halt the construction of a police and firefighter training facility just outside Atlanta that critics pejoratively call Cop City. Wondering if you and Kat were going to talk about this. Yeah, we are. We've talked about it offline before. I did a stream reading through the entire indictment like a month or two ago because it's funny. It's one of the dumbest things I've ever read, case or not. Their cases are at a standstill 20 months after being indicted under Georgia's RICO law, which is likely the largest criminal racketeering case ever filed against protesters in U.S. history. Trial for 5 of the defendants was supposed to start last year, but got bogged down in procedural issues. The judge overseeing the case then moved to another court. A new judge has set a status hearing for Wednesday. I think that was Kimberly Adams, the last judge. That's Armstrong, or is that his name? Armstrong, I think. No, Farmer. The delays have left people in limbo, facing charges carrying up to 20 years behind bars for what they maintained was legitimate protest, not domestic terrorism. The case also has suppressed a movement that brought together hundreds of activists to protect a wooded patch of land that ultimately was razed for the recently completed $118 million project. Protests escalated after the fatal 2023 shooting of Manuel Esteban Paez Terán, known as Tortuguita, who was camping near the site when authorities launched a clearing operation. Officials said they killed Tortuguita after the activist shot and wounded a trooper from inside the tent. Hey, Aaron. Good seeing you again. A family-commissioned autopsy concluded Tortuguita was killed with their hands in the air, but a prosecutor found the officer's use of force was objectively reasonable. The challenges of a 61-person indictment. Cases age like milk, not like wine. Prosecutors' decision last year to drop money laundering charges against 3 of the movement's alleged leaders was a sign of the case's weakness, to say the least. And with the movement having faded from the public consciousness, there is less political appetite for cracking down on the protesters. I want to crack down on the prosecutors. Prosecutors can't just walk away from it, but I think you'll probably see it die a slow death. It might not be that slow. It might be a rapid death at this rate. Julia Dupuy from Massachusetts. She's probably friends with Karen Reed. I bet she was all in on that. Probably helped Karen Reed get away with everything. No! Priscilla Grimm. Hannah Cass from Madison, Wisconsin. She's probably friends with, what's-his-face, Making a Murderer. What's his name? Stephen Avery. She's probably friends with Stephen Avery. Okay, anyway, that's the idea. There was a police training facility constructed. There's also a movie studio involved somehow, and it has something to do with, like, Black Lives Matter. Anyway, this is the indictment that I need to switch to so you can see it. This is the list of defendants. I did do a read-through of this entire thing, so I'm not going to read the whole thing. See, the indictment was August of 23, so just over 2 full years ago. You'll notice that there's no list of grand jurors. I don't believe that's been litigated yet, but you need grand jurors in a grand jury indictment. It's actually one of the most important things in a grand jury indictment is the grand jurors, but they forgot that. That's a whole special demurrer thing that's going to be litigated relatively soon. I thought this was funny because it says Brooke Lane Court March, aka Brooke Lane Court March. That's just not how that works. North Carolina wouldn't let Jamie Marsicano get their bar license because of the DeKalb County charges stemming from the South River Music Festival. Oh, I didn't know they were dismissed. I knew there was a DeKalb case because I think there was a discovery thing involving DeKalb County. This is one of the current defendants, I believe Marsicano is. Francis Carroll. Flags represented by Suzanne and Brian Tevis. If you're interested in that. Who else is in this current batch? Papali. What am I forgetting? I don't know. Oh, Ayla King was the first one to go. She had a speedy trial demand. She's represented by Shuri Chada Jimenez. One. What am I forgetting? 1, 2, 3. There's a fourth one. I can't remember who it is. Anyway, see here, intro, the purpose of Defend the Atlanta Forest, which might be the RICO name. Defend the Atlanta Forest. Anarchy background of Defend the Forest. Then there's this whole paragraph. It's actually multiple pages about like what anarchy is. It's collectivism, mutual aid, social solidarity. It's really bizarre. It's just a strange indictment, and they forgot the grand jurors, so I'm not even sure if it is an indictment. It's one of the dumbest things I've ever read in any context. And I want to be clear, this is not... It's very organized anarchy, Matthew. It's an organization. It's racketeer, influence, corrupt... anarchy. I don't know, man. It's so fucking dumb. Oh my goodness. It is so boomer. Mary, hi Jim Chat. So glad I made it to this live.
In partnership with Lysol, I'm restocking our back-to-school essentials at Walmart. We grab Lysol every year to help protect our home. I make sure I wipe the kids' lunch bags and backpacks to keep their...
Okay. The article I had open just started playing an ad in my ears really loudly. Yeah, I knew this case was going to be a disaster. I mean, from the second I saw this indictment, I was pretty sure it was going to be a joke. Oh, I was going to say, it is brought by the, it is anarchy. It was brought by the state attorney general. I think I said this a second ago. It's not by Fonnie Willis's office. So even though it's in Fulton County, it's not Fulton DA. It's the state attorney general. Like an edgy 13-year-old who draws like the A with the little circle on like his 3-ring binder for social studies class has a better grasp of anarchy than this indictment does. Like if you just ask somebody who didn't know what anarchy is, what anarchy means, they would probably give you a better answer than this indictment does. Like it's hard, like charging a RICO on anarchy is just fun. It just fundamentally doesn't make sense, right? I mean, anyway, I talked to one of the lawyers on this case. I talked to a couple of them actually, and his prediction for today's hearing was, hold on, I want to make sure I get this quote correct. Let me pull up our messages. Yes, we have a kind of weird inclusive motions hearing on Monday. I expect a slow motion train wreck. Was that a pun and I just missed it? We have a weird inclusive motions hearing on Monday. I expect a slow motion train wreck. I think that was a pun and I didn't pick up on it until just this moment. That's embarrassing. But I think he was wrong about one thing. I don't think it was very slow motion. I think it was a full speed, just a full speed train wreck, just full steam ahead, right into a cement barrier. with explosions. I think it was just a full blown, all out, full steam ahead train wreck. And I only listened to like 5 minutes of it, but I could tell from Judge Farmer's face. I could see everything that I needed to know. I could tell what what was going on. I could tell how it was going. Just his exasperation and general, his general vibe, his general sense. Cat Not Williams and I teamed up for a little I took these screenshots, and Cat was kind enough to repurpose them for the Cardi B. I believe that's a CD cover. You did, Cat. You did. I was just reiterating how stupid, like, fundamentally, the idea of an anarchy-based RICO case is. It just doesn't make sense, really. And there was an attorney. I think you'll know who I'm talking about. Nobody saw that. You didn't see that, and if you did, no, you didn't. Slow motion train wreck was his prediction. I just don't think it was very slow motion. So, okay, so I think 11 Alive had a stream. So I think I'm going to try to watch this one. If you guys saw the if you saw the full stream, let me know if I'm missing like a huge chunk. But I have like 2.5 hours of it here, which should be more than enough to get through. And then there's another several hours from the there's another 3.5 hours from 11 Alive's afternoon coverage. And from what I can see here, it looks like we have some funny footage of the judge's face, which is the most important thing. Exactly. Nobody saw anything. What was it that Yak said? What's the name of that song? Slime something. Slime. It's from. Yak Gotti. He said he has buddies on buddies, like friends. No, that's not the song I was thinking of. If I get caught, I won't say nothing. YSL bitch we mobbing, I'm for real. Yeah, like that. Anyway, so he said buddies. He was saying buddies. He was talking about his friends. That's all it was. Okay. Oh, I do want to show you guys one last thing before we get into it. I'm actually just going to show you guys how to do this because, I don't know, you guys might as well know. I'm going to show you guys how to get some of these documents. Go to high profile cases, Fulton County. If you get to this page here, this is all their high profile cases. You can see that they have the YLS indictments. So if you want the YLS RICO indictment documents, you can click on this. But anyway, once you get to this page, you just delete all of this, everything after index, and hit enter. And that will take you to the index page. And once it loads, you'll have all of these cases on the left over here. And you can get a bunch of different case documents, even some that aren't available, like that aren't categorized in the main Fulton County Superior Court website. They used to have the YFN RICO over here, but it's not here anymore. But you can see the drug rich RICO, which I think there's actually still pending a couple of cases. These are different defendants. So you can see like their case files here. Croy Bierman, if you're really into very important cases. But yeah, YSL here. After I spent thousands of dollars on YSL documents, I realized that they're all available for free. So if you want to look at like Antonio Sledge's documents, you could click on this. Anyway, so for this case, for the RICO case, you're going to want to click on this one. And you get all the names here. So you can see the regular indictment here, or you can look through any of the documents for individual defendants over here. Like today, Papali was one of the defendants. I think this is one of the funny ones. That is funny, but it's not as funny as I want. There's another one. Carol. Let's look at Carol. I think Carol had 1 billion demurrers. Yeah, here we go. So, so a general demurrer is basically saying that the indictment doesn't really charge a crime, or it's substantively defective in some way, and essentially you're saying that the charge should be dismissed. So this is just one defendant, Francis Carroll, who has 1, 2, 3, 4, 5, 6, 7, 8, 9, at least 9 general demurrers. Yeah, demurrer is just saying, basically it's just saying the indictment's messed up. I'll give you an example that's totally random that I'm just going to pull out of a hat. So this is the case of Antonio Sledge. So this case, this count is 16-11-133. And what to charge 133, you need to allege that a firearm was being used in the commission of a felony. So it's like, I'm a convicted felon and I have a gun and I used it to rob somebody. But in this indictment, they didn't say that he was committing a felony with possession of the firearm. They were just saying he had a firearm. So if you're a good lawyer, you could say, you could file, I guess it'd be a general demurrer. And you'd say, you didn't allege that Antonio was using the firearm in the commission of a felony. So you need to throw out this count. And that's what a demurrer is, basically. You're just saying that the indictment has some major mistake or flaw in it, and they didn't do it right. And either they need to fix it or dismiss the count. But basically, it just means the indictment's messed up. Exactly. If you're a deeply talented, lawyer. Here we go. So basically, every one of these, you see all these general demurrers are basically making an argument that there's a major mistake in the indictment, in the charging documents. A special demurrer is basically like there's a technical mistake that they need to make the indictment more clear, is usually what it means. There are details missing or something like that. But then there's also a motion to dismiss and a plea and bar, which is kind of like a motion to dismiss. Yeah, James, this is a lot. It's an impressive quantity of wrong in a single case. It's almost hard to make this many mistakes. And again, this is just the first 5. Oh, thanks, Created. Hey, Kels, YP. So again, there are 61 defendants. This is no, I think it's the first 4 actually. I think one of them is separate. Let me pull up my list. Yeah, there are only 4 defendants in this group. Let me see if I can. No, you can't see that. Anyway, there are only 4 defendants in this group. Mr. Schmidt, he did do this. Thanks, Mary. Yeah, this one is, there are a number of lawyers that are basically just waiting for their turn to explain why everything's messed up, which is kind of funny. It might be this one. Let me see if I have it here. Ooh, I want to show this. This is the last thing, and then we're going to watch the, and then we will watch the stuff. But this is particularly egregious. This was filed, I think, about 3 weeks ago, I guess. Special Demurrer 93. Who is he representing? I didn't even know he was on this case. I'm gonna be jealous of him again. Fantastic. So this is from about just shy of a month ago. Motion to order production of missing 7 terabytes of discovery. A terabyte, you may know, is a lot. I don't know how much it is, but I know it's a lot. It's what, 1,000 gigabytes, I think, is 1 terabyte? So what, 7,000 gigabytes? I don't know the difference between bytes and bits. Hey, Big Playboy. So this is from about a month ago. In this matter, the AG, unsupported by the Fulton County DA, it doesn't surprise me, Aaron, decided to prosecute 61 defendants for an exercise of their First Amendment right to protest. Like other aspects of the case, this is just A+ writing. Hold on, I'm gonna download this so I can mark it up a little bit. Here we go. This is just fantastic right here. Just sliding some shade in there. Like other aspects of the case, production of discovery has been a spectacle. In the face of numerous oral and written discovery deadlines, the AG's office has demonstrated its utter inability to handle a criminal case involving a high-volume discovery. Yeah, I know it's Brian. I think Suzanne's on the case too, Aaron. They're really great. Suzanne is representing DeMonte Thomas too, Donovan Thomas's brother. I got to talk about that at some point, but she worked for like a year to get Adam Abate to agree that the charges against DeMonte Thomas were wrong. And they went before Judge Cox, I think it was, with a stipulated amendment to DeMonte Thomas's sentence. And they were going to get for a 1-year reduction in like a 12-year sentence. And Judge Cox said no, even though both the state and the defendant agreed to the sentence reduction. So I know she's still working on that case. But when, Fonnie Willis says she cares about Donovan Thomas's family, just keep that in mind. This was by Michael Schwartz. But I do know that Xavier, I've seen some of his stuff already in this case. I don't really know him, but I know he filed quite a bit of stuff. But until last week, there appeared to be at least a common understanding among the parties of the volume of discovery, even if it was disorganized, difficult to access, and contained a computer virus. I didn't even read this very carefully the first time. That's incredible. Oh my goodness. Okay. The volume of information the AG had produced in discovery was between 7 and 8 terabytes, although the AG has stated that with the exception of the improperly produced attorney-client communications, discovery produced to the 61 defendants should be identical. Various defendants have reported receiving differing productions both in substance and in total volume. This is every single sentence is shady. This is like aspirational for me. Like, if I die and go to heaven, it's just going to be me writing stuff like this. I love it so much. Anyway, all indication from the AG's office were that though these 7 to 8 terabytes represented the entirety of discovery, but apparently that is no longer the case. Last Wednesday, August 6, 2025, at a hearing in State versus James Marsicano, number blah, 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 DeKalb County Superior Court, a stalled case in which the AG in DeKalb County, unsupported by the DeKalb County DA, is prosecuting the same conduct alleged here. The Attorney General's office announced that one reason for its inaction in that 2-year-old unindicted prosecution is, in part, the existence of 14 terabytes of discovery. 14 terabytes being approximately twice the volume of discovery the Attorney General has produced to date. Mr. Carroll moves for the court to order the prosecutor produce the other half, in italics, of discovery he apparently has not yet produced. Since discovery deadlines have gone unenforced in this case, his introductory clauses are just consistently hilarious. Just one after another. This is a man after my own heart. Like, it's just so shady. I just love every part of it. Look at all these introductions. Oh my goodness. Oh, it's so fantastic. Anyway, since discovery deadlines have gone unenforced in this case, Mr. Carroll defers to the court on yet another discovery deadline and merely asks that whenever the AG's office gets around to this production, the court afford undersigned counsel sufficient opportunity to review the material before trial. 12th day of August, 2025. Oh, I read the footnote. Is there another one? Okay, no. For Minecraft. Yeah, that's the whole thing. Although this is just one thing after another. Oh, no, it's fine. So this is just great work. I try to wrap my head around this entire case, but there's just too much of it. It's 61 defendants. A lot of them are just like clearly innocent. I know that Philip Flagg, who Aaron mentioned a second ago, I know that his case is especially weak. I believe they were trying to get a some kind of dismissal hearing, the Tevises. But I think there were just too many problems and too many people ahead of them in line. In like this very stupid line. Oh yeah. This is a very interesting case to cover. Yeah, there hasn't been a ton of news, but I think it's about to pick up for sure. Nope, not that. Okay. Where are you? So I think we're about to start watching the trial coverage here. And if you think you saw something, no, you didn't. Okay. All right. So this is the start. We just need this case's version of Operation Planters. I need to do a breakdown of that that PowerPoint at some point. It's so much worse than like the attention it got. It's so bad. But let's get into this. Let's see what's what.
It did not provide evidence in support of that, which is similar to what we're...
Let me see if I can make this sound quality a little better.
At this point, looking at here.
This is the start. I think they missed the first few seconds. But I'm sure we can get caught up.
Case quoted Blackman. Let's see if I have a citation for Blackman.
You're going to give me a minute to read all these cases, Mr. Hensel?
If you would like to, I will sit down right now.
Because I think you've just rattled off 1, 2, 3 plus the one I'm reading right now.
I'll take a seat. Let me know when
Now that being said, I did have a one-time reading this weekend, and I did not see those cases in here. Otherwise, I would have looked at them. Fair?
Fair.
Oh, it's being sassy already, but the direction of his sass, I suspect, is going to change. Unless that's
I didn't anticipate a quibble over whether or not the state would need to present evidence that it couldn't narrow the date range. I thought that was pretty settled and established, but fair that I did not provide citation.
That was, okay. That was a judge. I didn't think you'd have to think about it. It's so obvious anybody would know this.
I mean, I haven't heard counter citations, Your Honor.
Fair?
forewarned judge is a happy judge. I'm worried just at the out of the window. Look at this hippie. Look at that beard. Oh, I wonder if I'll see Schiffer in here. I know he went to the hearing today. Do we see him?
And this is from the gambling case. Instead, we, like the trial court, are bound by the record before us.
Let's see. Do we see any Schiffer? I don't see those red glasses just yet.
An absence showing by the state that its evidence was not permitted to identify the exact dates of the crimes, we must conclude
I don't see him here either.
that the indictment counts in question are imperfect and thus subject to a special demurrer. Is there a difference between, hey, we gave you a 2-year range, or they gave you specific dates in the indictment? It's from this date to this date. They didn't say a span of this year. The indictment is the indictment.
Look at this guy right here pretending to do work. There's nothing there. I can see it.
May 25th, 2020 and August 25th, 2023.
That's a date.
So they're alleging a specific date of May 25th. With more interested in this one. Which one was your Medicaid, the 251 or the 334?
Medicaid is Colby State, 334, Georgia Ave, 752.
Frankie's? Frankie's what?
November 1st, 2010 through December 27th, 2013.
So I'm guessing they're getting a special demurrer. A special demurrer is when you don't give enough information in the indictment. For example, you can say that, like in the Christopher Wolfenbarger case, there was an allegation that a murder occurred between, let me see, I think it was December, I don't know, it was somewhere between December and April 29th. December of 2008? No. December of 2003 or whatever, and no, December of 1998 and January or April 29th of 1999. So there was like a 4-month range 25 years ago. So you need to give like a specific date range so that the defenses can be prepared to, defend themselves. Not there was a crime that happened at some point in time. And I think the defense is saying that they don't have enough information on the time of the alleged crime.
That the sufficiency of an indictment to withstand a special demurrer is not.
Could have just waited 5 seconds and the judge would have said it for me.
Whether it could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he or she must be prepared to meet, and in case any other proceedings are taken against him or her for a similar offense, whether the record shows with accuracy to what extent he or she may plead a former acquittal or conviction. It is useful to remember that the purpose of the indictment is to allow the defendant to prepare his or her defense intelligently and to protect him or her from double jeopardy. Which of the multitude of microphones is blowing my court reporter's ears out? Okay. How you doing, Mr. Forte? Is that a problem?
A little bit.
Okay. I would note that of the multitude of overt acts in count one, all have specific dates on them. Does that not satisfy your specific dates within a date range?
Your Honor, I would note that an indictment is not evidence, and the burden is for the state to provide evidence that they could not narrow the date range.
Well, their date range runs from the date of the first of the overt acts. I mean, they listed a date range that is on the edges of the overt acts. Is that not specific dates?
Your Honor, I think we're parsing, but what I'm going to point out is the cases that I've referenced, starting with gambling, has specific dates. It has July 1st, 1998 through July 31st, 2000.
Yeah, I'm not entirely sure what the defense lawyer is getting at here. I mean, there are a million problems with the indictment, but I'm not sure. I can show you. I'll just show you real quick what the indictment shows for dates. Let's have it. Yeah. So these are the overt acts of count one. So they all have dates on them, roughly. So I'm not sure what he's getting at in terms of the dates. Just skip to Dawn. Okay.
Yeah, that's a date range.
Right.
And we agree on that. And you're saying,
Yeah, I'm not sure what he's getting at here. So I should skip to Don Samuel, who was also Wolfenbarger's attorney, one of his attorneys, along with Joel McDermott.
Hey, Mr. Kaczynski, Mr. Kaczynski, may you interrupt? That I'm going to stop your interruption right there.
Housekeeping question.
GSU Grinding has a minor crush on Mr. Samuel as well.
The court's made clear that for pleadings, we have to individualize our demurs, our motions, and can't just adopt. This is the first time in the case, I think, where we have an objection sort of procedurally that a defendant has lodged. Do you want the other three who are here adopting that contemporaneously?
We're going to have the Harvey rule here, aren't we? State the Harvey rule. Say no.
So I have to have all four of you say I want in on that one.
And my recommendation is that should be practice.
Yes. Unless otherwise stated, the three others will be joining in the objection. Unless you say, hey, Judge, I'm not in on that objection.
So it's
the Harvey rule. We should know. Now I'm just thinking of Steve Harvey. I can't think of his name. What's Harvey's? Bruce Harvey. In YSL, this exact issue came up because there were 28 defendants. And Bruce Harvey proposed a rule that all objections would be preserved. All other defendants would be deemed to have joined in any objection made by any defendant unless they specifically said otherwise, because Judge Glanville didn't want every defendant saying, I join in this objection every time there's an objection. And it was called the Harvey rule during the YSL case. And it's essentially the same thing that just happened here.
Opt-out.
It's an opt-out.
Okay.
Yes.
Understood. Thank you.
All right. Come on up, Mr. Samuel.
My most popular tweet for the longest time was when I tweeted thirst traps of Bruce Harvey from like the 80s. And I was salty about that for months.
And just like we discussed, Your Honor, before Mr. Samuel begins, because Mr. Samuel does not represent any one of these defendants, if we could just put it on the record that the defendants have no objection to Mr. Samuel arguing this for the purposes of later trial.
Fair enough. I think Mr. Hetzel actually, not only does he not object, he actually invited Mr. Samuel to testify on his client's behalf. So, any objection, Mr. Hetzel?
Not for me, Your Honor.
Okay. Any objection from any of the other counsel?
I'm not opting out, Judge.
There you go.
No objection.
There you go.
Judge, there's another housekeeping matter just before we get started with this.
I love this judge.
I did not think my house was that dirty.
Maya is coming after preparing for this
The caption gets another W.
motion, we won't talk about my house. So, Judge, one request that the state would have is when we talked about our scheduling conference, my understanding it was that we would handle, that each of them would argue, so Mr. Carroll, the attorneys for Carroll, Papali, and Marsicano, and Liberto, who would argue their motions to count, demurs to count one. And my request is, if we could go ahead and let everybody argue what they're going to argue on that issue where they filed it, and then I would respond all at one time instead of just my request, instead of responding to each, because it's going to get redundant, if that makes sense to me, for me. Just a request.
Oh, it's going to be ugly.
Oh God, this is going to be so much fun. This is going to be an amazing time. This is going to be a wonderfully amazing time. I can't wait. I'm so excited.
So, Mr. Samuel?
You want me to respond to that or just make my...
Just
all right.
My response is, please proceed, Mr. Samuel.
All right. Your Honor, I represent Marlon Counts, Della McLean, and Savannah Patterson.
Those are probably the three most central defendants.
Members of the Atlanta Solidarity Fund who were indicted co-conspirators in this case. There are many issues raised in our demur. I'm sure you read the motion, the original motion, and the one that I filed again in accordance with your request on May 30th of this year. There are scores of issues. Maybe I could group them together in certain ways. Many of them deal with my client.
Listening to GSU grinding, I know that Don Samuel is very academic and adept at formulating complex arguments, so I'm really looking forward to his argument here.
And not necessarily with one of the first four in the first group. So it's a little confusing, but I am going to address all the issues in my demur. I don't think it makes sense, as you did with the prior argument, to take one issue at a time and have a response. But if that's what the court prefers, I'll break it down into different issues, and you can get a response.
Just Mr. Hetzel sat down after the date range, and he wanted to argue the date range first. I'm here for you all.
Okay. Well, I will. If you want a response from the prosecution at any point during my argument, then that's fine. Otherwise, I'm going to proceed from one argument to the next. Some of my arguments or blend into both general demur and special demur, dealing with specific overt acts, specific aspects of the indictment, which we consider to be right for special demur. But I'm going to discuss all the demur issues in this initial presentation. I would point out that the prosecution, since we originally filed our demurs close to 2 years ago, has never filed a response to our demurs. They haven't filed a response when we initially filed the demurs. They didn't file a response in anticipation of the oral argument before Judge Adams. They didn't brief the issue after the oral argument with Judge Adams. They haven't filed a response in anticipation of this argument today. So the only thing I know about the prosecution's response is the oral argument they made when we argued this before Judge Adams. I don't know if the issues if their response is the same today. So
yeah, that was the prior judge, Judge Adams. I think Kimberly Adams. I think she moved to a different court though.
I'm a little bit at a loss to anticipate what their arguments are. I can't preempt what their responses are, but I will reserve time to reply to what I may be hearing for the first time when they finally reveal what their explanation is for some of the defects.
That was so academically shady. He's saying these lazy bunch of bitches didn't file any opposition to my motion, so I have no idea what they're saying. So I'm just going to wing it.
That's in the indictment. And of course, I'll respond to any questions you have. We have broken down the demur issues into several categories, as I said. One deals with the problem. I'm only in the RICO count, by the way. We were originally indicted on several money laundering counts.
Nalprost.
They were Nalprost because we filed the demur because they were so defective that I don't think even...
There were a variety of money laundering charges. I'll show those real quick. Those are down here somewhere. Here we go. They were all dismissed because of how dumb they were. Here's one. You'll see that there was a transfer of $61.21 from the Network for Strong Communities to Brooke Courtmanch for Forest Kitchen Materials. There was a transfer of $27.62 for Forest Tools. I don't know what that is. There's a transfer of $52 of $256. Damn, that's dollar bills. $27. Didn't we already see that one? Anyway, $12.52. That's 1,252 pennies. So when you think about it that way, it's a lot of money. $68.81. We were so close. $93, $99, $68, $140, $61, $48. Let's see, $107, $38, and that's it. I believe John Fowler is in this hearing today. Exactly, Creed. $14. You could buy like, I don't know, $14 worth of stuff with that.
The prosecution contended they could go forward.
My point being it was ridiculous.
Those counts. They've been non-pros, they weren't re-indicted, so we're just dealing with a RICO conspiracy here. My clients, as you know from reading the indictment, out of the 225 overt acts are listed, and 80, 90 of them, maybe even more than that. But they do fit into general categories. There's a category I refer to as the scenes no blog category of overt acts. There's this allegation, and I'm going to talk about this in great specificity, but I'm just kind of giving you the table of contents at this point. There's this allegation that our three clients, in addition to unknown co-conspirators, all authored calls to action, so to speak. We have seen no evidence of that in the discovery. Now, I'm not going to sit here and argue the insufficiency of the evidence, but it would have been nice had the indictment alleged some fact, any fact, that sufficiently alleged that the three members of the Solidarity Fund somehow had something to do with authoring documents that were, again, I'm going to refer to them as calls to action or suggestions that criminal conduct should occur. There's nothing in the discovery to verify that. And it also alleges in those counts that there were unindicted co-conspirators who participated. I don't know how many people in each one of those overt acts, the scenes, no blogs, overt acts, I don't know how many people are alleged to have supposedly authored these documents or somehow responsible for what showed up in a magazine or in a zine.
See no blogs?
It's this one right here. This is what he's talking about. He's talking about writing articles on this website, scenes.noblogs.org. Here's another one. So they're saying Marlon, Adele, and Savannah, along with unindicted co-conspirators that are unknown to the grand jury, did publish a post on scenes.noblogs.org. So we don't actually know whether it was Marlon, Adele, and Savannah, or it was the unindicted co-conspirators. An unindicted co-conspirator is somebody who was in the conspiracy, but was not actually charged in YSL. That would be something like Lil Woody or YSL Mondo, Bonnie Willis's former client, from Mondo Crenshaw, a founder of YSL, but not charged in the YSL indictment for some unknown reason.
Your Honor, if you take a look at the indictment, just the very first series of overt acts, look at just overt act 6, for example. That's the first one. 5, 6, 7, 8, 9.
Got it. The URL. Gotcha.
Yeah. And just so you know, and I'm not sure it's necessarily relevant to it, but we've even sat down with Mr. Fowler, I don't know, a year and a half ago, and said, where is the evidence that either Mr. Couts or Ms. McClain or Ms. Patterson authored these, submitted them? What does it mean to say that they are co-conspirators, along with unindicted, unknown co-conspirators who authored, these blog posts? And we were given essentially nothing. We were shown one document where the two names appeared on the same document. Atlanta Solidarity Fund and the Scenes blog appeared on in one document together. There's no other evidence we've been shown. Now, again, I'm not sitting here arguing that they got to prove their case in the indictment, but they have to allege the facts, which put us on sufficient notice so we can defend the case. That's the essence of a special demur.
Ooh, man, he's hitting that podium. It's getting me all fired up.
Sufficient facts so that the defense can prepare for trial. And they've alleged in the whatever you want to call them, scenes, no blog, overt acts, dozens of them. We're having to deal with trying to figure out who are unindicted, unknown co-conspirators. I assume they are not able to name them either, but at least by category. Where are these people located? What role did they play? What role did the three defendants who were listed in these overt acts? Over and over and over again. 3 people plus all the unindicted co-conspirators all supposedly committed every one of these 30, 40 overt acts, all dealing with the Seams blog allegations. I'm going to talk about those allegations more when I discuss some of the First Amendment problems here. So there are also numerous overt acts where they say there are known co-conspirators, but don't identify them. They've given us no information, zero information, about who the known unindicted co-conspirators are. Take a look at the overt acts beginning at 63 through...
All right, let's take a quick look at those. It says 63. That would be this one. Okay. It says Marlon, Adele, and Savannah transferred $105 in reimbursement from the Network for Strong Communities to an unindicted co-conspirator whose identity is known to the grand jury for materials and supplies. And if you'll remember, the ones we were looking at before, like number 8, I think, unindicted co-conspirators that are unknown to the grand jury. So now we have known co-conspirators that are, yeah, I do too, Matthew, that are known as opposed to unknown. I forget which number he said, but wherever we were, I think he said 63. Yeah, 63. Whose identity is known to the grand jury.
Somewhere in the mid-70s, you know, maybe not quite a dozen, but almost a dozen overt acts where they say the defendants, again, always putting them as a group, they rarely, sometimes, but rarely even try to distinguish between Mr. Katz, Ms. McLean, and Ms. Patterson. But they say they engaged in various criminal acts with known unindicted co-conspirators, but never provide us information about who they are. That's a special demur issue. There are...
Again, special demurs oftentimes have to do with not providing enough information to defend the case. That's what he's getting at here.
Out of the 224, 225 overt acts, it is impossible to figure out what are the actual predicate racketeering acts that are the object of the conspiracy versus overt acts which are perfectly innocent conduct. There's a clear distinction in the law between what is a racketeering act, a predicate act, has to be one of the codified crimes that satisfies the requirement in the RICO statute for to be a racketeering act, and an overt act, which can be perfectly innocent conduct in any conspiracy. If you and I decide we're going to go rob a bank, the object of the conspiracy is bank robbery. It's easy to identify, bank robbery. You give the elements of the offense, you know, an FDIC-insured bank, and et cetera, et cetera. An overt act might be that you and I had a phone call. That's not a crime that we had a phone call, or we drove to a store and purchased a gun legally. That would be an overt act, as opposed to the racketeering act, which is the actual bank robbery itself. The overt acts in this case don't differentiate between the two. And not a single overt act, not one, in this entire indictment, 224 overt acts, not one goes through the elements of any crime. So they really all are just overt acts, and there's never an identification of a predicate act in which they have alleged the essential elements of the offense. And we've cited to you the Heath case and the Sanders case. We put them in various places in our brief in which the court have said whenever there is a compound crime, and RICO is the essence of a compound crime, you have to set forth the elements of the underlying predicate offense. Not once in this indictment. The substantive crimes that I'm not involved in obviously go through the elements of the offense. But not one time in this indictment do they say that Mr. Couts, Ms. McLean, Ms. Patterson, committed the following, or conspired to, or did in fact commit any of the following crimes, or conspired to commit any of the following crimes, and then list the elements, so we can know that we're talking about, there's the conspiracy that the RICO allegation supposedly focuses on. They conspired to commit, the use of a Molotov cocktail to assault a police officer and go through the elements of the crime. Not once in this indictment does the indictment satisfy the Keith and Sanders rule that you have to set forth the underlying predicate offense with specificity, both factually, Sanders in particular does that, both factually and the elements of the offense. So we have
oh yeah, like and subscribe. I've been trying to think of funny ways to say like the stream. Like put the like button into Rice Street and don't give it bond or something like that. I don't know.
Problems identifying unindicted co-conspirators. We have problems with somehow throwing in co-conspirators. We have no idea whether they're going to claim that we were simply a party to a crime to some unindicted co-conspirator who committed this offense. And you're just kind of responsible on a kind of a Pinkerton theory. You know, Pinkerton, where every conspirator is responsible for what everybody else does. So we challenge the indictment for those reasons.
Pinkerton's a criminal theory. It's I think it's United States versus Pinkerton. I can't remember. I just know it as Pinkerton liability from law school. Basically, it means if you have a group of people that commit a crime, everybody in the group is liable criminally.
Failure to differentiate racketeering acts from overt acts in the indictment.
Because merely reimbursing someone for money is an overt act.
There's no doubt about it, it's an overt act.
Sure.
But you got to spell out in the indictment, and I'm going to come to this shortly, how did the overt act further the goals of the conspiracy? It's not just a question of proof at trial. When I gave you the example of a bank robbery, when you and I went to the store to buy a gun, yes, that's an overt act. But did we go to the store to buy the gun in order to go rob the bank? That's what's got to be in the indictment. You got to show how the overt act materially advances the cause or somehow is related.
You're so good.
All this says is we bought food.
Is the word you're going for nexus?
Yeah, of course. Well, it's the essence of RICO, is the nexus between the racketeering acts and the enterprise. The nexus between the racketeering acts and the overall scheme here, which is completely missing. But I'm not even there yet to talk about the relationship. The enterprise itself is shockingly ill-defined, if you will. I don't mean to get so overwrought here, but
get overwrought. Get over the rot is just so over it.
You know, that the enterprise is defined at various places in the indictment, most notably around pages 23, 24, 25.
Let's take a look at that just real quick, just so you can see. What is he, 23, 24, 25? Here we go. Yeah, this is the part where they just talk about anarchy. The self-identified coalition. I mean, you're identifying them right now. So, defend the Atlanta Force self-identified coalition and enterprise of militant anarchists. This is just... like, what are we doing here? Anyway, yeah, Shadowbox Studios, Anarchist Ideas. It's a group of anarchists that are trying to organize their communities. So yeah, I keep wanting to call him Bruce because he has Bruce energy. Don here is lamenting the fact that this is just it's just word salad, as James said.
This is all in the indictment. This is not, the introductory stuff. This is count one. They allege the enterprise, beginning on page 24, actually, and 25. At various parts, the enterprise is defined as a movement. Can you imagine that? That an enterprise is a movement? The civil rights movement would be characterized as an enterprise, according to the Attorney General's office in this case. At other times, they describe it as a coalition.
They're basically indicting Martin Luther King Jr. That's what they're doing here, Your Honor. They want to throw Rosa Parks in prison.
I I don't even know what that means. I know the word coalition means, but a coalition they describe of environmentalists, plus anarchists, plus eco-terrorists.
You know, when you say it out loud, it's even dumber.
I know what Mr. Fallon's going to say, or Ms. Nixon's going to say, or, you know.
Slide on the ops all the way to the like button.
Representatives from the AG's office, they're going to say, well, an enterprise can be just association in fact, and that's true. It could be a police department. It could be a governor's office. It could be anything. But somehow it has to have some defined structure. That's the United States Supreme Court case, Justice Alito of the Boyle case, in my brief. But the enterprise can't just be the acts themselves. You can't define the enterprise, which is the essence of RICO, racketeer, influence, corrupt organization. That's the O in RICO. There has to be an enterprise which is separate and apart from the acts that are committed. If you're just going to allege a bunch of crimes, you don't have RICO. And you have all kinds of venue problems at that point. You can't prove that the acts occurred in Fulton County or DeKalb County. You would have statute of limitations problem. If they're all part of the enterprise, that's why you use RICO, is to try to get them all into one case. But the enterprise here is so ill-defined and so hard to grapple with. And I'll point out that my predecessor up here at the podium, his argument's fine. I think his argument's wonderful. I think another way to characterize his argument is, if the enterprise throughout was to prevent Cop City, or the training center, was to prevent building on the farm, how could they allege predicate acts that occurred before either of them existed? They couldn't have been predicate acts relating to the enterprise. That, to me, is the problem with the date ranges they've used, with the earlier overt acts. If the enterprise was designed, the whole purpose of the enterprise, the existence of the enterprise, was to stop the training center and to protect the forest. Those were the essence of what put these people into one group, and yet it occurred before any of those things happened. Then the enterprise has lost all structure. Ms. Nixon says, well, we'll just prove it at trial. But they're not going to prove what they allege, because what they alleged as the enterprise had nothing to do with Rayshard Brooks.
I'll give you one example here from the indictment. Here is an act in furtherance of the activity. It's July 5th, 2020. And it wasn't, the training facility wasn't announced until April of 2021. So those acts would have been before anyone even knew about the training facility. So it logically can't be related to stopping the training facility, because nobody even had that idea yet.
That's the May and the shooting in May in Minneapolis, George Floyd.
Rayshard Brooks was here.
Rayshard Brooks was here, George Floyd was here. But that's the date range they're picking on. They're saying those events is when the enterprise began, and yet
yeah, it doesn't make sense. I'm not even going to try to explain that, but the indictment tries to link in George Floyd and Rayshard Brooks in Atlanta. I believe it was at a Wendy's, Rayshard Brooks. Don't worry about it. It's just confusing. We're not even going to get into that.
So throughout the rest of the cases, the enterprise is the forest, either the training center or the environmental problem. I just add that because of what the argument was before. To me, the date range is inconsistent with the enterprise that they've defined. That's the problem. And I raise it in our brief as a problem with the definition of an enterprise. That they are incapable of defining the enterprise with any meaningful structure or membership. Lord knows how many unindicted co-conspirators they're going to end up talking about at trial without ever
We're going to somehow get Lou Woody on the stand in this case too, aren't we?
Identifying them, or how many known co-conspirators they're going to identify at trial, maybe for the first time, since they haven't identified them yet. I mean, there may be thousands of people who they're going to say are members of this enterprise. They may say, because they suggested, any anarchist in the country. is a member of this enterprise. California, New York, Boston, they mention all of that. It's all
Hey, don't bring California into this. I'm innocent.
in their indictment, in their introductory sections about we're going to, commit crimes in New York and Boston and California, and we're going to go after this enterprise is larger than the Vietnam protests, as far as I can tell. As far as I'm concerned,
It's really showing your age there, Don.
if I was protesting the Vietnam War back in the 60s, I'd be part of the enterprise. Because some of the people committed crimes during those protests. What are you going to do with the NAACP? There were crimes committed. There was trespassing that was committed. There was civil disobedience that was committed. And there were even some violent acts committed. And some of those people belonged to the NAACP. You're going to say that's an enterprise? And it was all part of one RICO case because some members of the enterprise or some members of the group engaged in criminal conduct. The United States Supreme Court says you can't do that. The NAACP versus Claiborne Hardware, which we've cited in our brief. You can join a group. You can be a member of an organization or a movement or a coalition and not be guilty of a crime even if other members of the movement or coalition do commit crimes. And that's what they've done here. They've taken all these people and thrown them in an enterprise and said, here's your RICO. They're all racketeers. So that's, the argument that we make in our brief and our demur challenging the definition of an enterprise. It is too amorphous. It is indistinguishable from the acts, from the criminal acts that they claim that the enterprise members committed, and it sweeps in so many innocent people who are just members of a movement or members of a coalition, and then includes, as I said, how many hundreds or thousands of unindicted co-conspirators who are, quote, anarchists or defund the police individuals, or people who protested George Floyd, the BLM, or protested the Rayshard Brooks shooting. Now we know they're all part of it because they alleged it. That's when the enterprise began. The hundreds or thousands of people who protested, police brutality in this country. So that's our enterprise allegations. I don't even know where to begin with the 25 pages that Count 1 starts with.
I don't either.
I do a lot of practice in federal court. There's a lot of speaking indictments there. They have introductory language which is, in my view, offensive, but clearly tied to the crime. Right? There'll be introductory language, in healthcare fraud cases that explain a little bit about the history of Medicare and how it works, and it doesn't look like a typical indictment, but it's clearly focused on the actual crime that is set forth in the ensuing counts of the indictment. I'm talking about what we call speaking indictments in federal court. And I don't know if the Attorney General's...
Yeah, I completely agree. I just want to show... We're going to go back to the indictment here. Let me just find an example of what he's talking about. It shouldn't take me long. Basically, the start of where they... okay, this part right here. Anarchy is a philosophy that is opposed to forms... Hold on, let me just... Anarchy is a philosophy that is opposed to forms of authority or hierarchy. Beginnings of anarchist ideals date back centuries, though usage of the term anarchy did not exist until the 1800s. Over time, various philosophical forms of anarchy have emerged. Numerous anarchist philosophies exist, though anarchists are not required to subscribe to one particular belief of anarchy. Rather, the notion of anarchy, being grounded in an anti-authority mindset, primarily targets government because it views government as unnecessarily oppressive. So this is not really, it's not even really tied to the crime in the way Don's example was the history of Medicare relates to Medicare fraud. This is just talking. This is just yapping. about God knows what. Collectivism is the idea that individual needs are subordinate to the good of the whole society, even though in just the preceding paragraph it said that anarchists don't have to believe to any single here we are. They are not required to subscribe to one particular belief. And then in the subsequent paragraphs, they say exactly what anarchy is, which doesn't make any sense because you just said it doesn't mean any one thing. But yeah, it's just unrelated to the crime itself. Is this when the judge called it a political science paper? I haven't seen that yet, but very well possible.
In this case, tried to learn from that. But I seriously, Judge, ask you to really carefully read pages 25 through 49 of this indictment.
The court has read the entire indictment.
Yeah, well, you want to read it again because it's shocking.
You read it twice, read it a third time.
It's absolutely shocking that any prosecutor in this country would think that belongs in an indictment. I am absolutely appalled.
I am befuddled. I am flummoxed, Your Honor. I was crestfallen and heartbroken.
Attorney General's office in this state believes that it's appropriate to present to a grand jury and to present to the jury in this case, to you, to the public, to the press, 25 pages
to sweet baby Jesus himself
that discuss, can I quote just a few excerpts?
It's your record, Mr. Samuel.
It's their indictment.
That I don't have to read to a jury.
They read it to the grand jury. The jury has to be told what the indictment is that the grand jury returned. They can't return an indictment or a verdict for something the grand jury didn't indict for. And the grand jury, I've never been in a trial where the jury doesn't get the indictment to deliberate in state court.
I'm smiling so much at this, my face is starting to hurt already. We haven't even gotten to the trial yet.
But this indictment begins with talking about anarchist ideals. We're anarchists, you know.
All right, we're about to cook. He's about to cook. I can feel it. Look, Mr. Court Reporter. This face is all of us.
I mean, they clearly blame my three clients as being anarchists. Anarchist ideals date back centuries. Well, that's a hell of a thing we're going to have to defend against.
I love this guy. I'm sorry. I don't mean to keep saws. I had a moment. I'm sorry. Okay.
Blame my three clients as being anarchists. Anarchist ideals date back centuries. Well, that's a hell of a thing we're going to have to defend against. Is that going to be something that the jury is going to have to find beyond a reasonable doubt? Are they going to be told about the history of anarchism? Are they going to present evidence of that at trial? Violence is part of the anarchism in some anarchist beliefs. Anarchists often point to law enforcement as one of the chief violent actors in society. Violent anarchists often engage in...
Just think about what's happening here. Think about what's happening. His argument right now is just reading the indictment. That's all he's doing. His argument is just literally the words of the indictment. He's not even making, he's just reading. And it sounds dumb as hell. That's all he has to do, is just reading it out loud. Think about how effective of an argument that is. It's not even his word, he's just reading the stupid shit that they said.
Violent activity towards law enforcement. This is totally ill-defined. We're not talking about our case.
Your Honor, that's a run-on sentence.
We're not talking about our case at all at this point of the indictment. But you want to know some other examples? Well, they provide them in
This man is just... Oh my God, I love him.
the indictment. Examples include 2020 movement in Portland, Oregon, Seattle, Washington, the latter known as the Capitol Hill autonomous zone, that's in Washington. And of course, later there was the autonomous zone in Atlanta. This is all in the indictment. This is all what the grand jury was asked to sign their names to. And then it goes on to start quoting anonymous people, black-clad, masked people who get...
Let me see if I can find you an example of that. I know there is a block quote. Here we go. This is quoting a, as a result, violent anarchists often engage in violent activity towards law enforcement and is justified. This is my favorite sentence in the indictment, actually. This is my favorite, maybe my favorite sentence in any indictment. I forgot about this. I'm glad that it popped up right there. As a result, violent anarchists often engage in violent activity towards law enforcement. And it is justified because of the anarchist's belief that the ends justify the anarchist means. It is justified. Violence against, this is the state saying that violence against law enforcement is justified because of the anarchist belief that the ends justify the anarchist means. Anyway, that's just an aside. But here they're quoting a local anarchist supporting the Stop Cop City movement. This is an unidentified. Any of you guys watch Trailer Park Boys? You know when like Jim Leahy is always like the shit tree doesn't fall, the shit seed doesn't fall far from the shit tree, Randy. It's kind of like that, but with anarchy. Anyway, like if one of you got that reference, I'll be happy. But let me see if there are any others. There are other quotes. See if I can find any good ones. But yeah, there are various quotes from unidentified people throughout this indictment.
Speeches about defending the Atlanta forest.
I'm glad Teresa did.
They put that in the indictment, as if that's relevant to anything that's going to happen at this trial. Are they going to just abandon the confrontation clause? Are they going to put in evidence of what masked people said outside the courtroom, never going to be cross-examined about what this movement should be doing? We need to kill more policemen.
Whoa. Whoa. That escalates.
A known defend the Atlanta forest was recorded complaining that there were not enough violent members in protests against the training center. That's in the first 25 pages of this indictment. Then we get compared to Mexican Zapatistas, Syrian revolutionaries. That's what we're being compared to.
That does happen.
Kurdish revolutionaries.
I pulled that up for you. In one video, a black-clad Defend the Atlanta Forest participant refers to historical insurgents or violent guerrilla movements, such as the Mexican Zapatistas in Syrian Revolution, as a reference point for strategy and to anchor smaller movements to larger revolutions. Sorry, my dog was being bad. The black-clad Defend the Atlanta Forest participant states that the fate of the Kurdish revolutionaries in Kobani and Sarah Kaniv, I don't know that place, in all these places, it was partially determined by the bloodbath in Damascus and Aleppo, and I think that with the current movement here, it's clear to me that the fate of the South River Weelaunee Forest will be determined in Midtown Atlanta, and it will be determined in Chicago, and in New York, and in Los Angeles, don't put me in this, and in Seattle. Anyway, that's what he's talking about. But I don't know.
In Afghanistan. What is this doing in an indictment in this country? In this county?
What is it? You tell me, Don. You cook.
We raised all these arguments to Judge Adams. With all due respect, not a word in the original order in this case said there was anything improper about that. As if we all need a pseudo-history lesson from the Attorney General about, the background of my clients, their historical predecessors. This pseudo-history that has no business in an indictment. And I don't know what you're going to do with it. You're just going to throw it out and say,
I love this man.
We'll let the prosecution prosecute whatever they want in this case. We're going to throw out the first 25 pages, because that's clearly inappropriate, full of hearsay and confrontation clause and, as I put in my brief, events that happened centuries ago.
He's right.
I would really like, if I can pose a request to you, that you ask them, what in the heck was that doing in this indictment? What were those 25 pages designed to do? Who was the audience for those 25 pages? It is, I think I've already said it was offensive. That
it is tomfoolery.
you may be able to gather from my tone of voice. It is inexplicable to me why this indictment wasn't dismissed within weeks of it being returned with that kind of BS in it.
Oh.
We have devoted a substantial part of our demur to the First Amendment issues in this case. And they are, the indictment is just saturated with assaults on the First Amendment. It is throughout the indictment.
Would you say it's riddled? Would you say it's riddled with assaults on the First
From beginning to end, there are allegations of conduct which is clearly protected by the First Amendment, as if it's a crime. From the definition of the enterprise, you're an anarchist. Clearly First Amendment protected. That's like saying the enterprise in this case is full of people who belong to the NAACP. Can you imagine something like that?
Why don't you just indict all the elves in Santa's workshop since they're working together? Is that what you want? You want to put Santa Claus in prison?
Indictment. They say that the enterprise in this case was comprised of people who are anarchists, who are involved in protecting the environment, people who are engaged in direct action. I did that. Did you do that? I do it on weekends now, and I go out and do the No Kings marches. Is that an enterprise? Promoting anarchist ideas? Next thing you know, they're going to say it's a crime to promote democratic ideals or Republican ideals. As if that makes you part of an enterprise and violates everybody's First Amendment rights.
I'm a little more constrained than you are by the Judicial Code of Ethics, Mr. Samuel. I'm not out on weekends.
Say it again?
I said I'm a little more constrained than you are by the Judicial Canons of Ethics. I don't go out on weekends.
Yeah, well, I know I've seen members of my colleagues in the defense out there, and they wonder, I guess we're next, right? We're out there protesting, probably trespassing, not within the bounds of where the parade is supposed to be. The overt acts that so even the scenes block, even the offensive scenes block, it's going to offend the jury if you read some of these. But the United States Supreme Court has said, unless it's an immediate incitement of riot, Brandenburg versus Ohio and the United States versus Scales and all the cases.
Can you step away for 1 second? I'm going to let it play. I'll be back in like 30 seconds.
We read about in law school. Unless you are inciting a riot, you are not guilty, even if you're calling to action, even if you're encouraging what would be described as criminal activity. It's protected unless it is an immediate incitement to riot. We've cited those cases to you. I keep telling you that because I don't want you to blame me for bringing up cases here that weren't in the brief.
I wasn't blaming Mr. Hessel. I was just commenting.
Yeah,
Well, thank you, Your Honor.
we're on the same side here.
Couldn't tell by that.
Couldn't tell. Then we have the problem in the indictment, not just the First Amendment, which is part of the scenes broad problem, but the lack of any connection between, and mentioned this earlier, the lack of any connection between these alleged overt acts and any criminal conduct in the indictment. Now, Ms. Dixon may get up and say, well, we'll just have to prove it at trial. Well, these are demurs. And the basis of these demurs is you haven't given us the information to defend, number one. And number two, you haven't constrained what the jury can do. Because if you can say, well, you woke up in the morning, and that was an overt act, well, then they can prove anything at trial. They've got to prove what's alleged here, and then what's alleged here were overt acts that furthered the ends of the conspiracy. Buying food. Dozens of overt acts. You reimburse someone who bought food with no allegation anywhere in this indictment what that had to do with anything. Where was the food eaten? Where was the food brought?
Let me see if I can give you an example. Here we go. On or about January 10th, 2022, Marlon Cowsadell McLean and Savannah Patterson transferred, I guess it took 3 of them, to transfer $52.22 in reimbursement from the Network for Strong Communities to Brooke Courtmanche for Forest Kitchen food. This was an overt act in furtherance of the conspiracy. I guess he's going to say, yeah, what he's saying is that there's, like, how does reimbursing somebody for food further a conspiracy in any sense? You know, not that we know what the conspiracy is, but...
You know, there's nothing, and don't let them stand up here, the AG's office, and say, well, we'll show you a trial. They're supposed to show it in the indictment. That's what an indictment does. It's the blueprint for trial. It tells you where the structures are, where the steel beams go. Well, this doesn't tell us anything. You paid for food. You paid for Deep May, which was, maybe you remember seeing some of that in the indictment. It went, what the heck is Deep May? It was a computer training class for teenagers and young adults. There were professors who came from a university, came down here and taught people how to do troubleshooting on a computer. What is that doing in this indictment? And don't let them tell you, because it's not in the indictment. Don't let them stand up here and tell you, oh, I'll tell you what's bad about that. It's X, Y, Z. It's in the indictment. If it's...
I need to see that again, I'm sorry.
It's not in the indictment. Don't let them stand up here and tell you, oh, I'll tell you what's bad about that. It's X, Y, Z. It's in the indictment if it's going to be X, Y, Z. That's why we have indictments. That's why we have all the rules of discovery. But even that's not enough. If it's not in the indictment, then how's the jury going to know whether they're convicting them of something with which they are charged? The relationship between the racketeering acts and the enterprise is exactly what Kimbrough's all about. I think you mentioned Kimbrough when I stood up here. And that's kind of the essence of the demur problem. But that's just one problem. That just deals with the relationship between the crimes and the enterprise. And Kimbrough's clearly the lead case on that point. The First Amendment, there's just no shortage of cases, including, again, in our brief, the recent Ninth Circuit case that even found the federal statute defining riot act unconstitutional because it didn't clearly...
I once was a bartender at a comedy club called Riot Act.
And directly focus the incitement and the crime. It wasn't a close enough link. And all these scenes block allegations in the indictment are defective for that reason. I mentioned before this whole problem of all these overt acts that just have who knows how many different members, unidentified, some known, some unknown, and I have no idea. I've been working on this case for 2 years. I've been representing the clients for the time before that. You know that from the filter team problems. To say that Counts, Patterson, McLean, And a bunch of unindicted co-conspirators all did X. Well, how am I supposed to prepare for that?
They all did X? Well, that actually is pretty easy to,
All three of them did it? One of them did it? The unindicted people did it? But you're all being held responsible. You're all being held responsible because you're parties to the crime without any definition of who did what. Your Honor, the indictment in this case is, with all due respect to my colleagues, it is a disgrace.
The amount of respect due is 0, Your Honor, but I'm not going to say that out loud.
In this case is, with all due respect to my colleagues, it is a disgrace. It really is. It's a disgrace. It's an assault on the First Amendment. It's an assault on the right of people to protest. It is grouping all these people together and claiming that they're all a bunch of anarchists and criminals, that they should go to prison for the racketeering act of 20 years. Some of these people, were down here for one day.
Yeah, the sentencing range for a RICO conviction is 5 years minimum to up to 20 years. So yeah, 20-year maximum for a RICO conviction.
They went out, they protested, and they're now being labeled racketeers. My clients never.
Not that they really care about sentencing guidelines in Georgia, because Cat's going to make fun of me for saying this, but that's okay. Because, the sentencing range for 1611-131 is 5 years to 10 years, but apparently you can get 15 years for it.
Or alleged to have gone out to the forest. Not once. They are firm believers in the First Amendment. They exercise their rights under the First Amendment. They have a right to do that. You should be protecting it. The AG's office should be protecting it. And if necessary, we will be asking the jury to protect it. But you should put a stop to this, with all due respect, Your Honor. You should say, you want to indict someone for throwing a Molotov cocktail, indict him for throwing a Molotov cocktail, and don't indict 61 people.
This is remarkably similar to...
You want to indict...
Sorry. This is remarkably similar to the YSL case, where there were a handful of legitimate crimes that could have been charged as simple crimes, but they kind of, just stuck them together and tried to make a RICO out of it. There was apparently one Molotov cocktail thrown at some point during a specific protest. And a bunch of people are charged on the basis of that cocktail. But you can just charge the throwing of a Molotov cocktail, even as conspiracy if you want to, but you don't need to make a RICO out of it.
Someone for threatening a construction company, indict him for that, if you got venue. And I ask you to...
I love how he just threw that super nerdy venue argument in there.
Grant the general demur, grant the special demur, and tell the Attorney General this is not how we conduct criminal business in this state.
Tell him his mama's a hoe.
State.
Man, I almost feel bad for her because that is a tough act to follow.
Judge, I think I'm gonna start, do my best to answer what was alleged and argued, and yet still.
This is exactly what Samuel said. Don Samuel said. He said, they're going to stand up here and tell you what the indictment says, but don't let them do it. They have to do it in the indictment. And the first thing she says is, I'm going to answer what was alleged in the indictment. Exactly what he said was going to happen.
Stick somewhat to an organized presentation of the argument to you. To do that, I'm going to start with just a key point. Excuse me. First, one of the things that is important is there was an argument about the introduction as if it was separate from count one. I would just like to point out for the record that the introduction to this, which talks about, defines, and articulates facts pertaining to the enterprise, is actually contained in count one. It is part of count one. So that introduction in the body of the indictment is part of count one. That's just a housekeeping thing. However,
that's not relevant. Nobody's
there's a couple.
I think that was part of his complaint.
Yes. Thank you. Thank you. This face right here. Yes. Yes. And this face also. Also, yes. Just yes. Yes to this. My guy here needs to step it up a little bit. But yes.
Okay.
I think he agrees with you.
Agreed.
Mr. Samuel?
Yes. Yes.
Yeah. That's the problem. If it wasn't part of count one, who would care?
Well, and Judge, so I'll get to that. And there's a separate motion, and I think Mr. Fowler will address, there's a motion specifically about the political rhetoric and the
There are many motions regarding the political
agreed.
rhetoric.
Oh man, the judge is about to start cooking, isn't he? I love him.
And Mr. Fowler will be predominantly addressing that. I'll hit on it a little bit. But there's a lot of issues to cover. I'm going to try to hit them all. And Your Honor, the indictment in this case charges the necessary elements of conspiracy to commit RICO. And I want to and I know this after in response, it seems kind of anticlimactic to get up and just talk to you about the elements, but that is...
There is way too much preamble here. What are you trying to say?
What we're here to establish is whether or not the state actually alleged sufficiently the elements of the offense.
Get on with it, Junior.
And I won't go through all of exactly what is said because the court has read and studied the indictment. But count one does specifically set out that the individuals charged acted together, individually and as parties to a crime or as persons concerned with the commission.
Ma'am, are you arguing that the indictment charges crimes? We know, of
the crime, that is in there. They acted together with unindicted co-conspirators, together and with unindicted co-conspirators.
Did she say with unindicted co-conspirators and with unindicted co-conspirators?
It alleges the date range. It alleges that they did so while associated with an enterprise. They unlawfully conspired and endeavored. And it alleges the enterprise as well as the pattern of racketeering. And then, Judge, there's a lot in this indictment which the state is very well of, but part one defines the enterprise, and that's where...
Did she just say the state is you're the state, that is you. Why are you telling him that you're aware of your own words? That's just, we all... I'm not sure that she is aware of her own words, so let's just give her a second.
And then, Judge, there's a lot in this indictment which the state is very well of.
There's a lot in this indictment which the state is very aware of.
But part one defines the enterprise, and that's where they start.
Does it, though? Does it? I know you think it does, but does it?
A lot of complaints about the enterprise. And in part one, it gives the overarching intent of the enterprise. It gives how the racketeering activities are connected.
It's a bad political science paper.
Oh, I'd quit my job. I'd just walk out. I'm out. If a judge ever says that to me, I'm leaving. Not just the courtroom, like the state, the profession, probably the country. I'm going to Vietnam with what's her face? One of those Adelsons. I don't know. You will never see me again.
Activities of the enterprise. About the enterprise.
We're going to rewatch this 15 or 20 times, so I hope you're prepared for that.
And in part one, it gives the overarching intent of the enterprise. It gives how the racketeering activities are connected.
It's a bad political science paper.
The laughter in the background is. We gotta go.
It's a bad political science paper. It's a bad political science paper. I never thought a political science degree would help me. It clearly is the first time since graduating, other than from law school.
I'm sorry. I know this probably isn't good watching, but I'm doing my best to get through this. I'm sorry.
There's problems with this. Other than from law school. There's problems with this.
And Judge, I will get back to the or what might be surplusage or.
That's your response? I will get back to what might be surplusage? It's like somebody came up to your house and burned it down. And as you're watching your house burn down, you'll be like, you know, I completely lost my train of thought. That's just, my brain is broken right now. I had a point and I forgot what it was. I'm buffering right now, Trakisha. It made me buffer. I got secondhand buffering.
Or unnecessary in there. But the reality of it is that as far as whether we alleged, because one of the things they're saying is that
was Aleppo.
I'm sorry?
I'm sorry. I'm gonna stop. My bad.
How is Aleppo gonna go in front of a jury?
I'm sorry.
How is Aleppo?
Did she just hit us with a what's his face? Ron something? What is Aleppo? Okay.
Gonna go in front of a jury in this case.
Okay. Mr. Fowler said he'll handle that.
Okay.
He's gonna handle how Aleppo's gonna go in front of a grand. No, I want to hear it right now.
All right, Judge.
What does dipshit number 2 have up his sleeve that's going to explain how Aleppo is going to go in front of the jury?
So, to address everything, because we need to establish the record, there are 2 key things that are
already worried about establishing the record. That's bad.
In paragraphs A and B. 2 instrumental and key things. Paragraph A, the indictment alleges that each individual charged in this indictment knowingly joined the conspiracy in an attempt to prevent the training center from being built. It also alleges that the conspiracy contained a common purpose to commit 2 or more acts of racketeering. And then in count B, Judge, the indictment goes on as in describing the enterprise.
In paragraph B?
Yes, paragraph B in the introduction, Judge. It goes on to articulate and allege that the defend the Atlanta force, which is the defined enterprise, is a self.
It's not defined though. Yeah, it's hold on. You know what? No, she's gonna
identified coalition.
Listen to what she said.
It goes on to articulate and allege that the defend the Atlanta force, which is the defined enterprise.
Defend the Atlanta force is the defined enterprise.
is a self-identified.
It's self-identified? So, like, you need to identify it, though. You can't just say, oh, they identified it.
Coalition and enterprise, and then it goes on. And what is key, though, because we do have to allege the nexus, is that paragraph B to the introductions affirmatively alleges that Defend the Atlanta Forest, this enterprise, conducts direct action designed to prevent the construction of the Atlanta Public Safety Training Center and Shadowbox Studios and promote anarchist ideas.
Okay. Samuel's brought this up. There is stuff that predates the training center, even the announcement or conception of the training center in the indictment. So that doesn't work.
That the self-proclaimed direct action,
self-proclaimed and self-identified,
has included vandalizing private property, arson, destruction of government property, attacks on utility workers, attacks on law enforcement, attacks on private citizens, and gun violence. It also alleges that the purpose of these...
How do they relate, though? Like, how are you going to tie them back? And this is exactly what Samuel said. Don't let them stand up here and tell you how it relates. They have to do it in the indictment.
Actions is to prevent the construction of the Atlanta
That is objectively wrong because some of it predates that.
Public Safety Training Center.
You should know this. Samuel has addressed this. You can't say that. That's not an acceptable answer.
And a movie studio, all while promoting the virulent anarchist ideals.
Are you reading your own indictment right now?
So in the intro...
And how are you going to prove that they're virulent?
Paragraph to the indictment. It sets out what the...
It's not the intro to the indictment, it's the intro to count one. You just argued that 30 seconds ago.
Enterprise is, who this group is. It gives a lot of other detail, which I'll get to, but
it does give a lot of other detail, it just doesn't give the relevant detail.
Also establishes an allegation regarding a nexus between their activity and their end goal, or the motives and the end goal of the participants in the conspiracy, or the enterprise, excuse me. And so then in count two, I'm just gonna, what do we have to allege? Count two says the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below. The indictment then sets out 225 overt acts, some of which are predicated.
She's not even talking about count two's domestic terrorism.
And I'm going to talk, unfortunately, extensively about which of those are and what the law is there. But those 225 overt acts contain allegations of a multitude of racketeering activity acts. And they include influencing witnesses, assault, aggravated assault with firearms, domestic terrorism, arson, and acts and threats involving arson and felony obstruction. And
yeah, but which... Never mind.
Like I said, I'll address some of where that is in a moment.
I keep saying I'm going to address stuff later. Like, just address the stuff now.
But as the court knows, and as the defendants have argued in a lot of their motions, the test for general demurrer is, can a defendant admit all of the facts in the count, in each and every count, the entirety of the indictment, and still remain innocent?
That's, never mind, this is too, that's... No.
And I'm going to come back to that because Mr. Samuel didn't really address it, and I believe others will.
That's kind of a misstatement. She's right that that's usually the language. If you can address everything and be innocent, everything in the indictment and be innocent as to all of the charges, but you can have a demurrer. Never mind. This is too in the weeds.
But that is what the test is, and the state asserts that Judge, and we can pull it out, they absolutely, a general demurrer is not going to get them there, because if they admit each and every allegation in this indictment, they are definitely going to be guilty of multiple.
Nah. Who's they, though? Who's they? It's kind of an important thing. Who the they is?
Offenses, including RICO. Now, I'm going to go ahead, Judge.
I'm going to embarrass myself again. Just bear with me here, Judge.
All right. Whether the enterprise was sufficiently alleged, there's a multitude of arguments from different defendants about the structure. Mr. Samuel did mention it. And I'm going to read for the court. All right. Yes. Thompson v. State, 211, Georgia App, 887 at 890. It's a 1994 case, Judge. That is just one of the things it says, is that appellants contend that they did not have requisite knowledge of the criminal element of enterprise to sustain their RICO convictions. But none of the provisions of the RICO Act, however, requires that each and every defendant in an enterprise have full knowledge of all facts or all facets and elements of the enterprise, and that all members...
That's completely missing the point. I can already tell she's misquoting it. She's going to say that, okay, say you have 10 people that are in a gang, right? What she's quoting is saying that, let's do letters instead. There's A, B, C, D, and E are members of a gang, right? And they all know that they're in a gang, but A, B, and C off on their own do something as part of that gang, but D and E don't know about that. That means that D and E can still be liable because they're part of the gang, or RICO, I guess. So that language is about the actual operation of the gang, like as the gang, like pre-indictment, right? But she's quoting it to try to justify not giving information in the indictment about what happened in the past. She's misunderstanding what the law says. If you don't know the gang exists, that'd be a different thing. But she's conflating knowledge about what the gang is doing when you're in the gang and knowledge about what the indictment says about the gang. She fundamentally does not understand what she's reading. And I have read that case, but it's clear just from listening to what she's saying about the case that she doesn't understand it.
Or actors, and all of its members or actors. An enterprise is not a criminal act itself. It is a description of the entities involved in the RICO violations and may include activities involved in illicit as well as licit activity.
That's quoting the statute. That's from 16-14-3. A, I think. Maybe B.
It is the racketeering activity, the pattern of racketeering, the predicate acts, which is illegal, not the enterprise itself. Although the enterprise may be proved by the same evidence which proves a pattern of racketeering activity.
She fundamentally doesn't understand what she's reading, and she doesn't understand how it relates to the topic at hand. It's rambling. It's like...
And Judge, in addition... and we'll talk about the structure in a minute, but while some structure is required, this indictment more than does that. And in paragraph 3 of the indictment, as far as how we allege this enterprise, this indictment talks about how they recruit, how they're trained, what the...
Who is they? Who is they? Stop saying they.
Connection to each other is, what their motive is, what their end goal is, what different, it alleges different...
It talks about Aleppo inexplicably and the Mexican Zapatistas.
Paragraph 3?
Excuse me, I'm sorry, I'm just going... Paragraph 3 of the introduction explains how the propaganda, recruiting, providing finance, it talks about...
Just give me a page number, because paragraph 3...
I'm looking at it too, I'm wondering the same thing.
Count 1 has A, B, C.
Mm-hmm.
Part 1. You have part 1, then you have A, B, C, D, F, then you have part 2.
Gotcha.
So...
2 seconds, Judge.
I'm glad you did that. I was trying to look at it. I apologize. To figure out what you were talking about.
Part 2 is the overt acts.
Oh, she said part 2. I'm sorry.
think, what page is that?
Really? You were...
I think it's the bottom of page 28, Judge.
Bottom of page 28. Looks like this. The spread of anarchist ideas is conducted through word of mouth, internet, and written form. I guess things on the internet aren't written. As with any political ideology, the promotion of anarchist ideas exists and is spread on the internet. This is fucking great writing. See, the first sentence says, the spread of anarchist ideas is conducted through internet. Then to be clear, the next sentence says, as with any political ideology, anarchist ideas spread on the internet. Just because those are different things, right? The spread of anarchist ideas, internet. The promotion of anarchist ideas, internet. Once these also promote anarchist ideas through written documents and word of mouth. Word of mouth, written form. Word of mouth, written form.
And let me just generally characterize it, if I can.
That's the only way you can characterize it. That's the whole point, that you only can generally characterize it because you're not saying any names or who did what when. I'm sorry. I was too loud there. I'm sorry.
In the introduction, which the court has studied, the indictment sets out the propaganda, the recruiting. It sets out how finances are provided, who is provided, or what entities are providing, or how they shift money and pay money and what they're paying it for. It sets out how the enterprise provides support, emotional, personal, preparation for arrest. It alleges that it provides premeditation, or the enterprise premeditates committing crime.
The enterprise premeditate? Does the enterprise have a brain?
And that all of those things are part of this enterprise. On page 33, paragraph, anyway, it's...
Let's revisit that.
On page 33, paragraph, anyway.
Page 33, paragraph, anyway.
It specifically talks about, in the introduction, how this enterprise is designed and does promote and agree to promote conduct.
How does an enterprise agree to do something? Who designed it?
On page 27, a local anarchist supporting the Stop Cop City movement recently wrote, any idea who that is? Any idea how these people are supposed to know who that is? Any idea?
I'll show you that real quick. We just looked at that part. That's, oh, no, that's the wrong window. This one. That's this quote that we just looked at. The local anarchist supporting Stop Cop City. Creed says, I'm going to lose my shit now. Fantastic. Let's see.
As noted by the anarchist above.
Judge, I think it's, from what I understand, it's in the discovery, right? Is it a part of scene squad?
He's not asking you if it's in the discovery. He wants a name because he's the judge. Answer his fucking question.
Or is it one of the...
He's not asking you if it's in discovery. He wants a name. Answer his question. That's the judge.
It's in the discovery.
He doesn't want to know that. Unless the person's name is it's in the discovery, that's a terrible answer.
The indictment.
Yes.
So you're going to stand up here. You're going to be the state's person to stand up here and explain the indictment, and you don't even know who you're quoting in your own indictment. Where in the discovery is it?
When a court considers whether an indictment is sufficient to withstand a special demurrer, it is useful to remember that a purpose of the indictment, not the discovery,
Yes.
is to allow a defendant to prepare her defense intelligently. So, looking at the indictment, their argument is you can't fix an indictment with 10 terabytes of discovery.
And I understand.
Do you? Wait, didn't Whitaker say that to Love? I hear what the court is saying. Do you? That was a funny moment.
I understand.
They should be able to look at this 109-page document and go,
Yes.
Here's what we got coming at us.
Yes.
And unnamed quotes, that's problematic.
And as
It's in the discovery is not a good answer, is what I'm telling you.
That was a better way of saying what I just rambled about for 30 minutes.
So, and Judge, let me just go ahead and skip to this issue.
She keeps doing that. I'm going to skip to this. I'll get to that later.
So the indictment contains things, and I think
look at my guy right here.
Skip to this issue. So the indictment contains things, and I think in the last trial, in Isla King's trial, when we had it...
We have not had an Isla King trial.
Okay. In the previous court...
We have not had a trial in this case.
Right. Previously, when we prepared...
That's a slight detail.
For trial in front of...
That's Suri Chada Jimenez's client, by the way. She filed a motion for a speedy trial, or demand for speedy trial, and it got held up in the appellate courts. I should probably do a separate video on that at some point.
In this case.
Right. Last trial, in Isla King's trial, when we had it...
We have not had an Isla King trial.
Okay. In the previous court...
We have not had a trial in this case.
Right. Previously, when we prepared for trial in front of a different judge, we, with the defense, the state and the defense got together and they agreed that certain items would be redacted, and that, or certain statements, certain portions of it would be redacted. And that is, again, what the state's position is.
That's because that defendant announced ready for trial.
Not just that, but that's also an admission that the indictment's messed up. Saying, oh, we already agreed to fix our mistakes isn't the equivalent of saying we didn't make any mistakes. That's just, hey, please let us get away with the thing that we messed up previously.
By filing speedy. These folks have not announced ready.
And the state's position, and again...
I liked his little hand gesture there.
Have not announced ready.
And the state's position, and again...
Yes, Kim, that is right. I actually did a video on that. The grand jurors are not named in the indictment. You do need to have grand jurors in the grand jury indictment. I think there are some special demurrers pending on that. I don't think they've gotten to it yet, though.
Mr. Fowler is going to, do you want him to go ahead and do it instead of coming back around to it, because he is prepared to
I'm here for the duration. Y'all do whatever you want.
Do you want to go ahead and address the rhetoric issue? Because I think there's a separate motion. But let's go ahead and address that.
Thank you, Judge, and I apologize for kind of the we call it whack-a-mole way of standing up and sitting down. I think that's how the game works, but the way that the motion...
You could have just done a better job.
...were filed, so I'll go ahead and get right to it. And that is that one of the things...
I'm sorry. I just want to keep up. What motion are we on now?
I believe it's number 17 on your list.
17?
Yes.
No.
It's the same motion, and this is the issue that we had It's the same motion that they just argued, but
Did he just tell the judge that he's wrong? I probably wouldn't have done that myself.
Overlaps with 17 is what I'm telling counsel. And this was our difficulty in getting prepared for this, is that there are separate motions that are filed by certain defendants that also contain the same argument in the first motion that Mr. Samuel just...
Yeah, that's what happens when you charge 61 people at the same time, dipshit. Are you surprised that there's overlap when you have 61 defendants?
Argued. So that's when I say 17. It's a separate motion that was filed by Mr. Carroll that is on the list, that is also included in the argument that Mr. Samuel makes. So when I tell him 17, that's why.
Yes, Mr. Schwartz?
No, we're happy to cooperate here. Let's see how it goes.
Look, there's no question that there's a ton of overlap. And I understand that's why the previous judge may have done things the way she did. That's the way she's used to working, and that's fine for her. And I made you guys parse it out separately. That doesn't stop the fact that there is overlap between y'all's motions. So, all the housekeeping in the world isn't going to stop us from being a little bit sloppy and piecemeal. Go ahead.
Thank you, Judge. So let me start with this, which is that one of the things that was raised was the complaint that the Scenes blog did not adequately allege in the indictment that they are able to attack that. Now let me give the...
What was that sentence? What was that? What did he just say? What did he just say? Listen to the sentence.
Is that one of the things that was raised was the complaint that the Scenes blog did not adequately allege in the indictment that they are able to attack that. Now let me give the...
One of
the things that was raised was the complaint...
One of the things that was raised was the complaint...
The Scenes blog did not adequately...
That the Scenes blog did not adequately allege
in the indictment.
In the indictment. The Scenes blog did not allege adequately in the indictment...
That they are able to attack that. Now,
that they are able to attack that. One of the complaints is that the Scenes blog did not adequately allege in the indictment that they are able to attack that. The Scenes blog is a blog. It didn't allege anything in the indictment because it's a blog, not an indictment. So I guess technically he's correct. But who is they and what are they attacking?
Let me give the court a little bit of background because the court kind of made...
We don't want any more background. We don't want any more. There's too much background. You're talking about Aleppo.
A little of face when they started talking about the Scenes blog or scenes.blogs.com, whatever it is. And counsel is right that the Scenes blog is outrageous because what it does...
Don't try to flip this. Do not try to flip this. You're going to sound stupid.
As part of this conspiracy is get online, post online, hey...
The blog gets online and posts online. A blog is online. That's what it is. That's the blah. Blah. That's the blah part of log. The blog doesn't get online and post stuff. A blog is not a sentient being that writes stuff on the internet. I'm sorry, this is going so slow.
We just burned this stuff to the ground. We're going to do it again. And
who is we? That's the whole point. Who is we?
If you don't stop the training center, stop building the training center, we're going to keep building your stuff down.
Correct me if I'm wrong, Mr. Samuel. I think his argument was there's nothing in the indictment tying his folks to it. We got the metadata from their whatever. We got something. It's just these folks, along with people we don't know or unindicted co-conspirators that are unknown, along with people we don't know. So
did publish.
Basically, keyboard warriors.
Did publish. Yeah.
He just hit him with keyboard war. Chapeau.
Not just keyboard warriors. I mean, keyboard warriors get up and argue a purpose. This went further than that.
This went further than that. This went much further than that. This was intended to intimidate witnesses, and that's the allegation.
You don't know who it was, so you can't possibly know what their intent was. How do you know what their intent was? You don't know who it was. It could have been AI. I mean, probably not, because, it was 5 years ago, but you have no idea who it was. You can't possibly know what their intent was.
Because if you look at it, we give them the date, we give them the internet website, we give them the...
You gave them the internet website? I hate this person.
Contents of the post. We give them the intent of the post, and we...
Yeah, you don't give them who it was, though. That's the point.
Say who did it and that they published it.
No, you don't say who did it. You're lying. No, you're not lying. You have to be smart you have to know what you're talking about to be a liar. He's just wrong.
That is a lot of information. That is a lot of information to be part of an allegation. We didn't just say that they believed this. We didn't just say that they did this. We give them date. We give them date. We give them contents. We give them purpose and intent. We give them motive, and we allege who did it. That is...
No, you did not, you dipshit. Just raising your hand first of all, this pen, you need to upgrade, most importantly. Second most importantly, no.
Plenty to do it. In fact, we actually allege, if you take a look at it, we allege the elements of witness intimidation in that overt act right there, which would be sufficient as an independent crime in and of itself. But this is merely an overt act, and overt acts don't require that there are crimes. So not only did we sufficiently allege it, but we more than sufficiently alleged it. And I know that it appears that Mr. Samuel had his caffeine this morning when he got up here, but the reality...
Oh, you did not. No, that was an incredibly... No. When you're in the hole, you don't start throwing shade at the guy who just put you in the hole. You dig yourself out. This is not going to go over.
The reality is that we did more than we needed to do when it comes to the scenes blog sort of stuff. They claim that it's First Amendment protected, and there are First Amendment protections, and we're starting to get into a little bit of a different argument over breadth, which I will address differently, which I'll address a different argument, I think.
Maybe you could address that one well.
Unless I need to go ahead and do it now. But obviously, you can't just say anything that you want. You can't. There are limitations to the First Amendment when it comes to what
Who said it?
you say and in the things that you do. But I will address over breadth later on. Coming back to this, you don't have to allege how it furthered the objective. That's the primary. You don't have, or how it furthered the nexus. You don't have to allege that. You simply have to allege.
I'm dying to see where this goes.
Allege that it is an overt act in furtherance of the conspiracy.
Okay, I need to hear that again.
You don't have to allege how it furthered the objective. That's the primary. You don't have, or how it...
Objective isn't a word, it's object, the object of the conspiracy. It is the enterprise, it is the enterprise that conducts the conspiracy, and it's the object of the conspiracy, and by extension, the enterprise. I'm surprised
you don't have to allege that. You simply have to allege that it is an overt act in furtherance of the conspiracy.
That's the same thing. If it furthers the conspiracy, you have to have a nexus between the enterprise / conspiracy and the overt act, because you have to show that it's in furtherance. If there's no nexus, then it can't possibly be in furtherance.
That's all you have to allege. That is the only language that is required. And it is
this guy, neither of these people understand how RICO works. 100% that's the case. They just don't understand the law.
Sentence after all 225 overt acts.
You got a cite for that?
But it's back. I will get it to the court.
Of course.
Go get it. I want it now. No. If it's at your table, I want it.
Right.
What is the principle that you're reading?
This judge and I...
You don't have to
allege if something is an overt act in furtherance of the conspiracy. You don't need a nexus between that.
How do you have the full phrase is overt act in furtherance of the conspiracy? That's what an overt act is. It's an overt act in furtherance of the conspiracy. So if there's no nexus between the overt act and the conspiracy, then how is it in furtherance of the conspiracy? That's just how words work. I don't even need case law for that.
Overt act? Yes, the overt act. As to the political rhetoric, what the court called, I think, a bad political science paper, a bad political science
that was generous.
Paper we got from the defendants themselves in the documents that we located in search warrants in the forest and documents.
You put it in an indictment. How are you this stupid? How do you remember to breathe when you wake up in the morning?
That we found. This is where we get it. And it's important to understand that this is how we get here in this case. And I know it reads unlike anything we've seen before. It's certainly
I agree with that.
Something that I've never seen before. And
you've never seen the indictment before? I'm not surprised to hear that.
Let me give the court a different example of indictments that are fine when you do something like this. And I know we've talked about gang cases before. This happens in gang indictments too.
Oh, we're about to get real stupid with it. Let's hit me with what you got.
How do gangs get where they are today, leading to the violence or the fraud that they do, kind of depending on the gang. And you can do that. You can make that part of it. And I'll cite to the court I believe it's, and this is there's a Second Circuit case.
A federal case? That's not even the...
United States versus Scarpa, where the defendants unsuccessfully moved to strike 16 paragraphs captioned Introduction to All Counts, which was...
That's going to be a federal RICO, not a Georgia RICO.
Devoted to an overview and history of the Genovese organized crime family, which was a racketeer.
You're talking about the 5 families of the New York City mob? Okay, that's very relevant.
Prosecution and how it began and how it got where it got and the beliefs of the organized crime family and how all of those tied together. In addition to that, and even if the court doesn't think that that language should be in the indictment, what's interesting is that counsel filed a demur, but I'd point the court to a...
You're going to give me set on that one?
I'm sorry.
It's a Second Circuit case.
Yes, it's 913 F. 2nd 993, page 1013. I would also give the courts United States versus Belomo, Bellomo, 263 F. 2nd 561. And so you don't have to scroll forever. It's pages 584 through 585. Now, I know that counsel filed a demur to the indictment, but demurs are not the proper vehicle for this. The proper vehicle and the remedy that counsel needs to ask for, and the proper remedy is if there is surplusage in the first part that this court does not think needs to go to the jury, in which case it would be surplusage. The state doesn't have to prove it. Would be to ask for it to be redacted. And there's a case, it's just an opinion out of the Superior Court of Cobb County, so it's not persuasive on this court, but it's well. Redacted. And there's a case, it's just an opinion out of the Superior Court of Cobb County, so it's not persuasive on this court.
I just made it an incredibly articulate and reasonable argument. Just take my word for it.
But it's well written, I will say that.
It's not persuasive, you're a Cobb County.
That's what I said. Oh, God, man. I would have sounded so smart. He said it's not persuasive authority. Man, it is persuasive authority. He meant to say it's not binding authority. This is like a very basic concept. You don't need to know this if you're not a lawyer, but it's a pretty basic concept. Binding authority means it's a higher court and you have to follow it. Persuasive authority would be something like another superior court, which is what he's citing to. But the judge is laughing at him for saying it's not persuasive, because that's exactly what it is.
On this court, but actually, it's just an opinion out of the Superior Court of Cobb County, so it's not persuasive.
He meant to say it's not binding, and it is persuasive.
On this court, but it's well written, I will say that.
It's not persuasive, you're a Cobb County.
It's not binding on this court. How's that? Maybe that's the better.
Probably could have just let him talk for 3 more seconds.
Terminology. I don't know which judge wrote that, but I hope they're not listening right now.
You don't know what.
And it is 215 Georgia Super Lexus 7038. And it's a finding in a motion for new trial. The trial counsel was not ineffective for a failure to file a non-timely demurrer. And they don't really talk about the timeliness.
For failure to file a non-timely demurrer? Okay.
But it does say, in such a situations, a motion to strike the surplusage, which was never filed, rather than a dismissal of the entire count, is the appropriate remedy. And it cites to United States versus Fulton. That's 285 F. 2nd 378. It also says that even if an indictment is lengthy and needlessly verbose, does not mandate that it need to be dismissed. Instead, the defendant's proper recourse is to file a motion to strike surplusage from the indictment. That's United States versus Watson, 2008, U.S. District.
I just love, because fundamentally, what he's arguing is like, yeah, we're stupid, but we're not stupid in the way that they're saying. So, like, best case scenario, if he wins on this argument, it's like, we're so stupid, but, you know, we're stupid in this other way. And so, Your Honor, you should rule for us.
Lexus 59323. There are Georgia cases on that as well, where the cases have found that refusing to strike surplusage in an indictment is harmless. That's, I think it's Malov, M-A-L-L-O-V. I'm not really.
You think? Bitch?
I don't think it cut it off in Malloy. I think it's Malov, however you say it, versus the state. 293, Georgia 350. Supreme Court dealt with an indictment charging Medicare fraud, which included language beyond the statutory language. The court noted that surplusage does not vitiate an otherwise valid indictment. And that cites to State versus Barnett, 268.
To those who Whitaker, he's very far afield right now.
Georgia Appeals 900. I would note that in the Barnett case, the court ordered that the term family violence be redacted from the indictment in the introduction. It doesn't really get into how it wasn't, but somehow it made it to the jury. And the court later found that that wasn't an issue because it wasn't something that the state had to prove. And so this allegation that the jury read it and therefore convicted because they were somehow poisoned by that or tainted by that, the court dismissed that and said no, it has to do with the evidence that goes before the court. Finally, there's another case that stands for it. I'll go ahead and give it to the court. It's Eidson versus the state, E-I-D-S-O-N, 262, Georgia Appeals 664. That's a 2003 case. So I give the court all of that to let the court know that even if there is any a part of that, it shouldn't be in there. The proper remedy is a redaction, like Ms. Dixon was getting at when we were preparing for the Isle King in front of Judge Adams. That the proper remedy is to redact it. Now, we never...
Remember how we started this argument? How Mr. Samuels had too much caffeine? And now he's arguing, oh yeah, we fucked up, just, you know, not that way. Like, he's conceding the fact that Samuels is right after he insulted him.
Reached that for a number of reasons, but that's a totally separate issue we're not addressing today. But that would be the proper way. I would suggest to the court that it's not. That these are things that these defendants had in documentation, things that they wrote, things that they said.
You explicitly said that it's people not indicted, so that's just objectively wrong.
All of that sort of stuff. And this history lesson, while I agree with you, it's an unusual history lesson, comes from these defendants themselves. It explains how we got here.
You put it in the indictment.
and the motive for the reason that they do things. And we talk about that a little bit in the indictment. When we talk about the nexus while promoting anarchist ideals, and we talk about that as part of the nexus and part of the violence and the property damage, the gun violence, the arsons, the going after civilians who are just doing their jobs, all of that sort of stuff is part and parcel of this case. And for those reasons, we believe it should go out with the jury. If it doesn't, the proper remedy is merely redaction. And I believe that I will now turn it back over to my colleague, if I may.
Okay.
So that's the state's response regarding the alleged rhetoric in
the alleged rhetoric. It's your co-counsel just said it was rhetoric
in the introductory paragraph, Judge. The other things that the state has argued, or the defense has argued, particularly Mr. Samuels,
he's the only one who's argued so far,
is that the indictment is violative of the First Amendment, and in the speech and the assembly and the right to associate. And again, we'll have other motions, so I don't want to hammer the point. It was a passing reference in multiple of these. But first and foremost, the reality of it is, read the indictment, because it is this argument that they're making that the state, through charging this, basically said if you protest you're a racketeer, is essentially ignoring the contents of the indictment. The indictment makes it very, very clear. And quite frankly, my co-counsel and I have talked about this, we unabashedly and absolutely unequivocally agree that who you associate with, what you believe, in the quiet of your own home particularly, what you may say to somebody, that you can believe completely different, you can believe unpopular, you can believe popular. None of that, all of that I should say, is protected, 1,000%. But what you can't do is, because of those beliefs or for any other reason or some other belief, you absolutely cannot agree and join in with a group of individuals who are associated in their conduct and in the way they conduct themselves, in their beliefs, whatever it may be. They are associated in their, in fact, in the way.
She's trying to land this sentence very hard, and I think she understands that she just talked herself into a hole.
They are conducting their affairs. You cannot agree and become a part of this enterprise, therefore, and agree that you're going to, or your co-conspirators, or somebody else in the enterprise is going to go out and commit certain crimes or acts or threats involving certain.
You can, actually. She's misstating the RICO statute.
Crimes. And we'll get to that in a minute.
She's absolutely incorrect. That's not a crime. You can't further the conspiracy, but if you want to join in a group and somebody in the group commits a crime, that's you're not liable for RICO. She's objectively wrong again.
So the reality of it is, people can get up and wave their arms and yell and scream about the First Amendment and become insulted and indignant.
I very rarely get offended, but I'm actually unironically offended right now.
But this indictment in no way is talking about this.
She's so dumb. And, she's not just a bad lawyer, she's a bad person.
The indictment is charging people not with their beliefs. Their beliefs are their motive. They're evidence of their motive. What they say is evidence of their intent and their motive. Absolutely. The state will say, yes, that's true. That's an established law in this state and elsewhere. That speech can be used as evidence of intent and motive. But the reality of it is that while you can associate with who you want, you can protest. You can peaceably.
She's contradicting herself.
Assemble, you can protest, you can do all of those things. What you can't do, shoot a police officer, hold a gun on a guy's head who simply showed up. He's just a metal scrapper, and it's in the indictment. I'm not proffering.
What are you talking about?
It's in the indictment. You can't hold a gun to a guy's head because he acted upon you and hold a gun to his head with a deadly weapon, by the way.
Really? A gun's a deadly weapon. Can I get a citation for that?
So, ag assault, you can't shoot fireworks at EMT and firefighters. You can't burn down or try to burn down buildings. You can't burn up the police cars of the Atlanta Police Department. You can't destroy construction equipment. You can't threaten and terrorize people.
Nobody's arguing this.
You can't do those things. And if you do those things, and you then...
This is one of the dumbest arguments I've ever heard.
Also agree with others and take the steps and commit the other elements of conspiracy to commit RICO, yes, you have committed a RICO. And it's that basic.
You have committed a RICO? You have committed a racketeer never mind.
This is not about what they believe. This is about what they did. And what they did, not to the police, just to the police, not just to firefighters, not just to EMTs, not just to law-abiding citizens who work and have built companies and had contracts to have something to do with this, or in some way to build or construct or to clean or whatever, the police public safety training center. It's a mouthful. It is not. In the end, it is about the criminal actions that they took, that they agreed to take, that they knowingly understood that this group and this enterprise was going to take. It is about that, and that is what the indictment charges. Now, does the indictment charge a pattern of racketeering activity? And I need my glasses. Excuse me, Judge, I apologize. Bear with me, Judge, if you will, please. This particular issue within this case is a little bit convoluted and complex, as
yeah, we agree. It is a little bit convoluted.
Seems like everything to do with RICO charges. But I'm going to start, Judge, with just pointing out, and some of these cases have been cited by the defense in their motions.
What cases?
But Borders v. State, 270.
What is she citing these cases in support of?
GA, Georgia, 804, 1999.
Why are you citing cases?
The court said, the Supreme Court of Georgia said, an indictment apprises the defendant that he may be convicted of the crime named in the indictment, of a crime included as a matter of law in the crime named, and of a crime...
This is about lesser included offenses. What is she talking about?
Established by the facts alleged in the indictment regarding how the crime named was committed.
This is about lesser included offenses. What? This is about being put on notice for a lesser included offense. Like, for example, if you were charged with 1611-133, but the elements allege 1611-131, you're put on notice of 131 if the elements are alleged in the indictment. But that has nothing to do with anything she's talking about.
And an indictment is void if it fails to establish or charge a necessary element. Second premise.
She has no idea what she's talking about. She has no idea what she's saying. She genuinely does not know what she's talking about.
Judge, is while a defendant may desire greater detail, and this is and specifically English v. State v. English, 276 Georgia 343 at 346. Specifically, I know that they want more detail. They want everything and anything that we're going to argue, allege, our thought processes, how we plan on and strategizing for this trial. Yes, they want that.
I legitimately hate this person.
But in English, the Supreme Court of Georgia said it is not required that the defendant get every detail of the crime. In in State v. Wyatt, 295 Georgia 257 at 263, and here's I know this goes back to what you mentioned already. However,
this goes back to what you mentioned already. What are you talking about?
Georgia Supreme Court says, instead, it's not necessary that the indictment contain everything they need to know. It's not. Instead, additional details desired, the additional detail desired may be supplemented by Pre-trial discovery he or she receives, and any investigation their counsel conducts. And so it is interpreted and is anticipated for the obvious reason. I don't need to keep reiterating that.
What are you?
It's blatant. We don't have to allege every single fact that they may want to know in the indictment.
Let me stop you right there, Ms. Dixon.
Yes.
Thank you, Judge. I was getting sad just listening. I usually happily angry, right? I was just like sad angry because it was so stupid that it wasn't even fun to be angry anymore.
Yes.
One, I'm going to cite from Kimbrough, which cites from English.
Yes.
To be clear, we do not mean to suggest that a RICO indictment must contain pages and pages of extensive detail about the connection between the enterprise and the pattern of racketeering activity. We hold only that the sparse allegations of this indictment, which says nothing at all about the nature of the connection, are insufficient to enable the defendants to prepare for trial. And in that regard, let's talk about, hey, can you conspire with people that hold guns to scrappers' heads, etc.? No, but if you're Mr. Liberto, for instance, not picking on your guy, he is named in one overt act, under 143. That on or about January 18th.
I need to see this. Say 143. Yeah. I'll show you that real quick. Oh, not you. There we go. So this is his only overt act, apparently. On or about January 18th, Liberto did attempt to occupy the DeKalb forest with Wait, so his only act was in DeKalb County? Did attempt to occupy the DeKalb forest with camouflage, camping gear, and living supplies. This was done to prevent the construction of Cop City. This was an overt act in furtherance of the conspiracy. Just attempting to...
2023, he did attempt to occupy the DeKalb forest with camouflage, camping gear, and living supplies. I don't know if you've been out on Martin Luther King Jr. Drive, but there's folks out there wearing camouflage with camping gear and living supplies. So any homeless person in that park should be part of this RICO?
No, Judge, not unless there is...
Not unless there's a nexus to the RICO.
What are kids doing these days? Is it like this? What's the little K-pop? Is it like this? The K-pop part? I want to do that right now.
Where is it?
In the allegations, Judge?
This was done to prevent the construction of the Atlanta Public Safety Training Center. That's what you're going to point to.
Yes, and the introduction that talks about the direct actions as well as the common purpose. And I'll go back, Judge. You're going to ask me for a cite, but let me say it and then I'll go find my cite with the court's permission. The bottom line is that one of the things we will have to prove is not that each defendant agreed ahead of time or then later committed predicate acts themselves. So what we will have to prove at trial is that the defendants then later committed predicate acts themselves. So what we will have to prove at trial is that the defendants knowingly joined a conspiracy that they knew had a common purpose of committing predicate acts for the goal of the enterprise in this situation. I'll just apply it to this case. And so an overt act is alleged against Mr. Liberto.
An overt act in furtherance of the conspiracy. It's like they don't know the full phrase. You need a nexus.
That's all we have to allege in the indictment. And again, I'm not saying that the indictment couldn't be better. It could.
Nobody's arguing that.
Of course, any indictment. But is it sufficient to put him on notice? Yes. The indictment tells him, or tells them all, that they what the DTAF, the Defendant Atlanta Forest Enterprise is, where it got its beginning, some of the things that
Is she dense?
surrounded it, how it's structured, it does allege that, how it is financed, all of that. And then it says, these defendants, each individually and as a group, as parties to the commission of the crime, conspired to commit RICO, and
to commit RICO? I'm sorry.
The law will be that we have to establish, and then it alleges the predicate acts. So while I understand that he's charged in one paragraph, that's his overt act. And we allege that it's in furtherance of the conspiracy and that it's in furtherance of the purpose of the enterprise, more important. And just that's what we have to allege. Now, that's not all we have to prove, again, but that is what we have to allege.
Yes.
Does that answer your question?
It's an answer.
Did you see that? Fuck yes. Yes.
We have to allege.
Yes.
Does that answer your question?
It's an answer.
Okay. And so, as far as going back to the issue of whether there's sufficient do you have other questions about the stuff I've talked about before I move on? The issue of whether there's predicate acts, and we've argued this before, Judge, but let me hit a few more points. One is and Mr. Samuel didn't argue it, but I'll go ahead and point it out, that it is not simply just within count one that the court must look. The court must look to the entirety of the indictment, along with the statute, that State v. Bear 303.
The Kimbrough case that got overturned seemed to say otherwise.
Well,
because that was, the Court of Appeals was like, well, if you look at the whole indictment, you get the main picture. And the Supreme Court said, no, that's not how it works.
So, Judge, for example, Sanders, which is a 2022 case, which is cited by the defense, 313 Georgia 191 200. When an indictment charges a compound felony, and maybe that's the issue. This is a conspiracy. Maybe that's the issue. I would need to look back at Kimbrough. I apologize.
I think you need to look back at a lot of stuff.
Because there, Kimbrough, the Gwinnett County folks took an indictment and they said, and they incorporated counts 5 through 20 and then 25 through, they incorporated the counts into the RICO count. And while the Court of Appeals thought that was fine, the Supreme Court said, we disagree. And I understand the state's argument is, hey, that's why we put all these overt acts into count one.
To put them on notice, and then the elements are filled out with the remaining count, or two of them at least. And that's not my only argument, Judge, but Sanders, was Kimbrough a conspiracy case? I don't know.
Sanders a murder case.
Okay. Well, so if it's a direct murder, Judge, then the distinction, then I can answer you what the distinction is. The distinction is that when an indictment charges a compound felony, that is different, or a compound crime. And are you look? Should I just hush and let you read Sanders real quick? Okay. Basically, Sanders stands for the proposition, and it's well adopted. It's not in question. That when an indictment charges a compound felony, such as conspiracy, the count charging the compound offense must contain the essential elements of the predicate offense, or the indictment must contain a separate count charging the predicate offense completely, or the indictment must elsewhere allege facts showing how the compound offense was committed. And a challenge that a count in the indictment must be vacated because it did not allege the essential elements of the underlying offense is a challenge to the form. Anyway, so in this, we have to prove that the defendant conspired with one or more people to conduct or participate in the defendant Atlanta Forest through a pattern of racketeering activity, and that one or more of the co-conspirators committed overt acts in furtherance, which goes back to somewhat of what you mentioned before, Judge, and technically, we don't have to prove that each defendant or allege
I'm dying to see where this sentence goes.
actually did the overt acts. One of the co-conspirators must do an overt act. So it's to Mr. Liberato.
No.
And I'm sorry to jump around. But as to your point about Mr. Liberato earlier.
Did she just say that you don't even have to do an overt act in furtherance of the conspiracy to be liable, criminally liable for a violation of the RICO statute? Because that is questionable.
We've alleged a conspiracy, so every single one of...
I think she's confusing the difference between proving the existence of a RICO enterprise as opposed to criminal liability for an individual defendant. And when I say I think she's doing that, I mean she's doing that.
Those 225 overt acts are attributable to him because
they fundamentally don't understand how RICO works.
Once we prove, of course, but in allegation, because he is alleged co-conspirator and he is responsible for the overt acts of his co-conspirators.
That's not how
That's
works.
it. Again, we do not have to allege that an individual defendant committed racketeering acts, but rather that the defendant committed overt acts in furtherance of the conspiracy, and those acts don't even have to be crimes. So
that part is true. That part's true. The overt acts in furtherance of conspiracy do not have to be crimes, but they still need to be in furtherance of the conspiracy, and that gets to the judge's point about how there are people in the forest with camouflage and supplies who aren't doing things in furtherance of the conspiracy. So why is Liberto criminally liable if there's no further nexus alleged?
We do not have to allege or prove that the defendant agreed to that he himself will commit predicate acts. And I'm going to cite it's 2025 Jordan versus State 375. And Judge, I have some of these cases if you want copies. But
what do you mean you have
375 Georgia App 552 2025 case? That is citing the Cotman case. And Jordan says a person may be found guilty of RICO conspiracy if they knowingly and willfully join a conspiracy which itself contains a common plan or purpose to commit two or more predicate acts. They don't actually have to intend to commit the acts themselves. Now.
But how do you join? That's the point.
As to whether we alleged predicate acts, one of the most important aspects of the RICO statute that I think has been missed, and not just by these defendants, but a lot.
I hate her so much.
Is that the plain reading of racketeering activity under 1314.3, and it's
that's not the statute.
Many subdivisions leads to the conclusion that has been adopted by the Supreme.
Did she say the wrong statute?
And it's many subdivision racketeering activity under 1314.3.
It's 16. 16 is the criminal code. That's literally every crime in the state of Georgia. How do you...
And it's many subdivisions. Leads to...
I'm not even a member of the bar in Georgia.
The conclusion that has been adopted by the Supreme Court of Georgia.
1614.
Excuse me.
Thank you. Thank you.
Probably going to do some things like that. I apologize, Judge. 1614.3. That not every act of racketeering activity actually has to be a full and self-contained crime. And so as the court knows, but I'm going to go through it for the record, that we have to allege a pattern of racketeering activity. And under 1614.3, subsection 4, we have to allege either
okay, no, that one's right. They changed that one.
At least two acts of racketeering activity in furtherance of one or more incidents with the proper.
I can't keep explaining this, but what she's talking about is whether a RICO conspiracy exists. And yes, those don't necessarily.
a relationship, and I'll just abbreviate it that way. Or we have to allege that they engaged in one or more acts of domestic terrorism. And then racketeering activity, so it's one of two ways. Either it's at least 2 acts of racketeering activity, or
trying to figure it out on the fly.
At least 1 count or at least 1 accusation of domestic terrorism. So when you come to it, how's racketeering activity? And this is where it gets interesting, Judge. Yes, everybody knows about 1614.3.5a. Everybody is aware of it. It says that racketeering activity.
What statute?
Judge, yes, everybody knows about 1614.3.5a. Everybody.
3.5a? Three, 5A? Oh, is she talking about this? She's just listing the...
Everybody is aware of it. It says that racketeering activity includes to commit, attempt to commit, to solicit, coerce, intimidate another person. And then it goes on to say, gives, I think it's 43 categorical or categories of criminal offenses. So, for example, assault, and then it'd be any of those assaults under that.
Sure, but we're talking about going camping, and that's not any of these.
Article and chapter. But that's one way. B is the second way. So 1614.3.5b says that racketeering activity shall also mean any act or threat involving ... So murder, robbery, things of that nature, arson, and felony obstruction of justice is included. Well, arson and obstruction of justice, which is punishable by imprisonment for more than 1 year. So, with the plain reading of that means that if we allege in our indictment domestic terrorism 1 or more times, 2 adequately, 2 predicate acts under 5A, which would involve the criminal offenses, or 3 acts involving arson or felony arson or felony obstruction of justice, that if within the entirety of our indictment we have done that, then we survive demurrer.
No! This is inexcusable. Okay, so what she just described is the standard for establishing that there is a RICO. Not that an individual is liable for violating the RICO statute. So an individual can file a general demurrer, which is basically a motion to dismiss, in other words. Most jurisdictions just call something like that. Because they personally aren't a part of the RICO. She's confusing that a RICO exists with that a single person is a part of the RICO. That's really funny. Married, yeah, that's... She does. Your mom is a wise lady.
And I'm going to give you the case that specifically says that 5B includes not only, or adds to the list of criminal offenses by saying acts or threat involving. And that is in 2005, it's Dorsey v. State, 279 GA 534 at 540 through 541. And in that particular case, Judge, the state had alleged multiple different paragraphs of predicate acts for the racketeering activity. One of those was, I think, paragraph 5. It doesn't really matter. They had a paragraph, and in that paragraph, they alleged that defendant, let me get it right, committed acts involving murder, which is one of the...
See, if you did that, you'd be fine, but you didn't do that. You just said he went camping.
Allowed crimes. And then it says, in that he met with 4 co-conspirators for purpose of planning, that the conspirators conducted surveillance and obtained firearms, that Dorsey covered for Cuffey and when Cuffey was questioned by law enforcement, and that Dorsey employed co-conspirators in the sheriff's office as consideration for their participation. And
wow, that sounds extremely shady. Do you see the difference between what she just read and Homie went camping? Do you see the difference between this guy met with a bunch of people and planned out a murder, and then there was some corruption in the sheriff's office with respect to the criminal conspiracy to commit murder, as opposed to he went camping? And if you do, you're smarter than Miss whatever her face is.
And, lastly, that he discussed alibis. None of those were criminal offenses.
Excuse me? You just named like 6 criminal offenses.
And so what the court in Dorsey said was that, and specifically, that Dorsey argued that those were not sufficient because they didn't establish all of the elements of a criminal offense, and the court rejected that and pointed out that 3.5b includes acts involving. And in saying so, they actually reference and cite to a case, United States versus Miller, it's in the other case, which says, interpreting the federal RICO statute, defines racketeering activities as encompassing any act involving murder to include an act which need not be murder so long as it directly concerns murder. All that to be said.
Does camping directly concern murder? I mean, the way I do it, it does, but generally speaking, I don't think it does.
Under this acts involving, all right, we do not have to allege that the defendant or defendant.
His face is priceless right now. Whoever said that is completely right.
Committed an act of arson. Well, we do allege that. We don't have. That's one way.
You're so dumb.
We do not have to allege as a separate, fully set out accused charge that they committed felony obstruction.
Who is they? Who is that? They don't seem to understand that there are different individual defendants in a RICO case. Like, that's really the critical point here. You need to have criminal liability for every criminal defendant, even if you prove the existence of the RICO.
Under B...
Keisha, you're right. I don't know why I'm doing this myself. I was happy a couple of hours ago. I had pancakes this morning, and they were tasty. And now all I can taste in my mouth is hatred.
According to the Supreme Court, and according to a plain reading of the statute, which differentiates itself from A, we have to allege acts or threats involving a narrow amount, narrow classification of charges.
Camping. Talk about camping.
But one of those charges is arson and another is obstruction, with the modifier that it has to be felony. So felony arson and felony obstruction. So, I cite to that case as adopting that practical and plain reading of the statute. And so those are the 3 ways we can do it. And so going back to what I indicated earlier, Judge, bottom line is you have to read, the question becomes, is within count 1 or within count 1 referencing other counts, or basically are there facts anywhere?
Camping! Talk about camping!
And the indictment pulled together that can establish the racketeering activity. And my assertion is that we have done all 3, and just for the record. All right. Under 4B, under 4B, if we have sufficiently alleged domestic terrorism, one-time, done deal, pattern of racketeering activity is alleged. You don't have to allege, unlike the other issues, you don't have to allege multiple incidences of domestic terrorism activity. You have to...
Why is she this stupid? I can't wrap my head around it. She's not even talking about the right topic.
set it out fully and completely, but only one time. And the indictment does so. Section 2, paragraph 152 of count 1, in the overt acts that include predicate acts by the language of the indictment, expressly stated, states in on or about January 21st, 2023, Naja Gear, Madeline Fiola, Emily Murphy, Francis Carolyn, Ivan Ferguson joined the night of rage in Atlanta, caused arson and property damage, and thereby committed the offense of domestic terrorism. Now, obviously, as far as domestic terrorism, that doesn't lay out the elements of domestic terrorism. The state's not saying that. However,
slow down, Ms.
Yes,
Dixon.
I'm going too fast.
You're going too. I know you're going too fast for Mr.
Yes,
Forehead.
I apologize.
So you're going to 162.
Yes. Oh, 152.
152. Not to put Mr. Roberto on the spot here. But is it going to make a difference that post dates his one day in the park?
Very specific.
I'm sorry, Judge. I can't.
Okay, Mr. Liberto is alleged to have camped on January 18th of 2023.
Okay.
This predicate act of which you speak in paragraph 152 occurred on January 21st.
She completely forgot what she was talking about. She doesn't even realize the question she was supposed to be answering when he references the question that she was supposed to be answering. She has no idea what's going on.
After Mr. Liberto went camping in DeKalb County.
Right. It's an ongoing, continuous litany of activity. And so I see what you're...
So how does that tie him in? You got to show how that ties him in. Because if somebody goes camping and then 3 weeks later somebody burns something down...
So it's really
So if I go by an Italian Ice at a mafia-sponsored parade...
That sounds fun.
I'm cooked.
No. No.
Okay.
Absolutely not. If there's evidence, however, that beyond what overt act, again, we don't even have to allege an overt act, but we
I paid $1 for that Italian Ice.
Then that might have been a crime.
I love how she's just getting roasted in front of an audience.
Because that sounds really cheap, Judge. I mean, you know, what they say about...
No, you are the joke right now. You don't get to make jokes when you are the joke. It doesn't work that way.
You know, if it's too good to be
It was
true.
a mafia-sponsored event.
But if it's too good to be true... Anyway.
Nope.
Sorry. So, bottom line is, Judge, no, obviously, because there's no evidence of other... Well, if that's all you did, okay?
How is he on notice? That's his point.
I'm only an hour and 56 into this video, and I've been streaming for 3 hours and 15 minutes. That's a bad sign.
How am I on notice that camping furthered this conspiracy?
Because he's alleged to have. He's alleged.
No! Okay, we need to listen to that whole... No.
There's no evidence of other... Well, if that's all you did, okay?
How is he on notice? That's his point. How am I on notice that camping furthered this conspiracy?
Because he's alleged to have. He's alleged.
It's got what plants crave. It's got electrolytes.
And it's explained. And now given, there is not a specific for each of these 62 argument or about how the state knows what it knows about Mr. Liberto, for example. But it accuses and alleges, which is what we're here for. And it says, Mr. Liberto, we are telling you to be on notice that you are accused of conspiring to do these things and to commit this RICO Act. And then, of course...
To commit this RICO Act? Ma'am, do you know what RICO stands for? To commit the RICO Act?
How RICO is defined, that comes from the statute, it comes from case law. But maybe this answers your question, I'm not sure. The bottom line is, Judge, he doesn't have to have agreed specifically to certain criminal acts. He has.
Excuse me? Okay.
Has to have agreed that predicate offenses or acts.
Ma'am, do you know what a predicate offense is? Offense. He's going to call John Floyd, I swear to God.
Not just offenses, predicate acts will be committed in. These words get so overlapping, but the predicate acts.
Your brain gets overlapping.
Acts will be committed in pursuit of the purpose of the enterprise. At least 2 will be committed. He has to do so knowingly. And the conspiracy itself, or the enterprise itself, has to have a common purpose. And that.
We're talking about camping, ma'am. Please talk about camping.
That's what we have to prove. So while one overt act.
He's just laughing at her.
Is alleged in the indictment, that is not
overt act in furtherance of the conspiracy, not just any overt act. Like right now, what I'm doing is overtly acting, but it has to be in furtherance of the conspiracy. That's the second part of the phrase that really matters. I just keep thinking of Harold Camping. If you guys are familiar with Harold Camping and the End of the World, every time I say camping, I just think of him. So that's been a little funny side note for me.
The extent to which the state has accused him of being involved. The state has accused him of conspiring to commit RICO, which 2 or more acts. It's in the indictment. So that's one act. Let me
listen to what she just said.
Accused him of conspiring to commit RICO, which 2 or more acts. It's in
2 or more acts.
The indictment. So that's one act. Let me keep going. Which is after the fact, but it is a continuing enterprise. And I understand what you're arguing. Your argument is, okay, well if
I'm not arguing, I'm just pointing out facts.
Your point is, if he was in the, but that's not the only. But again, it's not the only incident that he's aware of, or he was involved in, or that we have information on.
How does he know?
Did she just admit?
Again, it's not the only incident that he's aware of, or he was involved in, or that we have information on.
How does he know that from looking at the indictment?
Exactly.
Because he's accused with conspiring to commit and
I'm gonna lose it. I thought that it couldn't get any worse. This is special. This is generational.
And that he knows at least 2 predicate acts occurred, or conspiring to commit 2 predicate acts, basically. And so
now he's conspiring to commit 2 predicate acts, but you only named him in 1?
That's how he knows, because he's charged with it.
Go on.
And again, Judge, he doesn't.
Hey. You laugh, you leave. It's real simple.
I would be gone by now. I would have been gone an hour and a half ago.
It's real simple. Sheriff, next person that makes a noise, gone.
Also, people have been laughing repeatedly for the entirety of this hearing.
Want to giggle out in the hall? Fine. We're not doing that in here. A little decorum, folks.
Didn't he laugh once at one point?
And people can giggle and people can laugh and
not in my room.
They can. Bottom line is, Judge, we don't have to even we don't have to allege or prove that he committed an overt act. We don't have to allege.
What? You don't have to
allege or prove that he committed a predicate act. We have to allege and prove what is alleged, which are the essential elements of conspiracy.
You don't have to prove that he committed an overt act?
Not that he or one of his co-conspirators. Yeah.
So you don't have to prove he did anything?
Not, well, I mean, not an overt act. No, we do not have to allege or prove he committed it. It's he or any of his co-conspirators. That's the law on this conspiracy. Mm-hmm.
You don't have to prove that Spencer LeBaron did anything? I think that's a good time for lunch. That's a good time for lunch. See y'all at 1 o'clock.
Let me correct that.
He says, I can't laugh, and then she's going to say something like that? Huh? That's entrapment. That's entrapment is what that is. That is me being entrapped. That is not fair.
His co-conspirators. That's the law on this conspiracy. Conspirators. Yeah.
So you don't have to prove he did anything?
Not. Yeah.
So you don't have to prove he did anything?
Not, well.
Just.
Yeah.
So you don't have to prove he did anything?
Not, well, I mean, not an overt act. No, we do not have to allege or prove he committed it. It's he or any of his co-conspirators. That's the law on this conspiracy. Mm-hmm.
You don't have to prove that Spencer LeBaron did anything? I think that's a good time for lunch. That's a good time for lunch. See y'all at 1 o'clock.
Let me correct that predicate act.
No, this isn't the Glanville. You don't get to keep talking.
Sure. After she talks to me. Sure.
All right, we taking a break? I say we take a 2-minute break for lunch. Bathroom break. You can get some popcorn. You can get some, what are we looking for? Get whatever you need. I'm going to be back in like 2 or 3 minutes because that is just, I need a mental health break. So yeah, let's give it 2 minutes and I'm gonna keep going. That is a good call, Aaron. That actually is pretty funny. Oh my goodness. Trenton attempting to argue they only have to prove a predicate act occurred within the RICO. Yeah, exactly. She's mixing up like proving the existence of the RICO conspiracy with individual liability for the RICO. She's like kind of right about two separate things and trying to make them into one thing. We're legitimately fighting against the legal system to send us to prison for agreeing with certain politics and deeply disturbed me in this case gotten this far. Yeah. I agree. It's I mean, this case is bad for a number of reasons. Yeah, Aaron, that's a great call on this. So yeah, Trenton's right. He said she's attempting to argue they only have to prove a predicate act occurred within the RICO, but saying it in such a way they don't have to prove the defendant was in the RICO. Yeah, that's right. You still need to tie each individual defendant to the RICO, essentially. Yep. At the lunch break, she called Love for Help. Yeah, just to be clear, this is the state AG's office, so this isn't a Fonnie Willis special. Okay, it's been 3 minutes. Let's keep going. That isn't very loud.
In May of 2020.
Seems like we missed a little bit, but we're just going to have to keep going here. I'm guessing he's talking about the fact that there were overt acts alleged that predate the Atlanta public safety facility, whatever it's called.
Our argument...
And that is in the indictment. Yes. That is the stated purpose of this corrupt organization.
So, yes, Judge, yes. And
so why are we predating that? Because they could not have been Shadowbox Studio, Public Safety Training Center, not a thing in May of 2020.
So
and like I said, I hate to backpedal.
No, you're fine. Of course you're fine. Excuse me, Judge. No.
My job is to be curious.
My argument regarding that is that the enterprise, which had this goal of this trifold goal, and that the evidence will bear it out, but that the argument is that the conspiracy, notable Judge, that the conspiracy, okay, existed from those dates. And let me make sure I've got I want to get technically accurate.
Just accurate would be fine.
Excuse me. Here we go. Where is it?
Okay. These are very basic questions, really. Like, why is something, if there's a triggering event in 2021, then why is there stuff in 2020? That's a very basic, obvious question. I don't know why they don't have an answer to that. It seems like you should be able to predict that that's going to be an issue.
So that they were associated with an enterprise, and you're, I think, saying how can
this is a bad argument. She's saying that the enterprise existed, and its purpose had nothing to do with the training center because the training center wasn't a thing. So if the enterprise existed and it had a different purpose at this point, then it couldn't exist for the stated purpose, the alleged purpose.
And the enterprise with this purpose exists before the public announcement. Before, what I will tell you is that the date range of that conspiracy is alleged.
Don't do it.
Based on the information that we obtained through evidence that we received. And
Scott, what plans crave?
During the course of the investigation, whether it be...
And what is that information? What does that information say?
Statements of an alleged co-conspirator.
What statements? What do they say?
Which were not testimonial, so don't invoke the confrontation clause.
What in the name of God? Why are you talking about the confrontation clause? What information?
But statements of a non-indicted or statements of a masked co-conspirator, we'll say.
A masked co-conspirator? Like Mass Effect?
That way. We believe we know who it was, but regardless. Statements of a masked co-conspirator.
Masked.
And, again, Judge, under that logic, under their argument, the Network for Strong Communities, which was a core part of this whole thing, I mean, the record shows that they were created, incorporated in August of 2020. So
that's bad for you. That's not good. That's bad for you.
Argument is that while the indictment alleges a date range, it then follows up with specific dates that actions occurred.
Okay, but we're talking about the 2020 dates, so...
And so, as far as notice and all the case law they cited about notice, every single act charged as either predicate act or overt act has a specific date. So none of those cases...
Nobody's disputing that it has a date. That's not what we're talking about.
Are applicable to us.
Is Atlanta Forest?
Does it exist within the continuity of time, or does it exist outside of time?
Organization?
Are applicable to us.
Is Atlanta Forest the corrupt organization, or is Network for Strong Communities the corrupt organization?
Atlanta in the indictment, it's defending the Atlanta Forest. Network for Strong Communities is part and parcel of it. It gets...
She doesn't... This isn't helping you.
It's very convoluted.
Like, it's dumb and it hurts your case. It's not even like a neutral dumb.
But it's part and
I think you're...
parcel of it.
It gets very convoluted.
It's very convoluted. But it's...
Correct.
Part and parcel.
I think that's exactly what the defense is telling me. And they're asking me, it's way too convoluted. I look at it, I can't see it.
Well, I'm not saying that the indictment can't be seen. I'm saying that the facts of the case are convoluted. Because, I mean, that's part of the intent. I won't get into that. But
it's part of the intent? What? What?
But it is... We...
Just yes. Just...
Into that.
Wait, is this... Yes, thank you, Aaron, for pointing that out.
But it is...
You're on the same wavelength right here. Look at their faces. They've been working together for a long time. You can just tell.
We alleged the beginning of the conspiracy on that date based on evidence we received to include a co-conspirator's...
What evidence?
Unindicted co-conspirator's statement. That is part of why we included the date that we included. The specific overt acts are then alleged, and we're going to be restricted to allegations of those overt acts. However, Judge, I mean, under anybody's rational, just common sense approach, before the first overt act, an enterprise can exist. I mean, that's just common sense. I mean, it can...
Nobody's disputing that. It's the part...
exist before they first take an act, or before they take an act that we charge. And so, yes, we have alleged that the enterprise and the conspiracy...
I agree with you.
Yes, okay.
An organization can exist.
Yes.
Now let's talk about purpose. Okay?
Okay.
It can exist.
Got it.
They could have... Atlanta Force could have been in existence since, I don't know, 1900. But Public Safety Training Center didn't come to existence then. I mean, how are they acting with a purpose for something that doesn't exist?
Judge,
or
it can be in the planning stages of it. They may know it's coming.
No, it can't. Oh my God. You can't.
I mean, and probably Mr. Fowler may speak better to this, but...
Well, I mean, he was up here saying, hey, that's when they heard about it,
right.
And that's when Mr. Hetzel is like, okay, fantastic, let's hear it. Where is that in the indictment? Mr. Hetzel, is I wrong there?
To clarify, I'm asking for the state to produce a witness or some other evidence that somehow gets us to May 25, 2020, instead of the first overt act listed, which is July 2020, instead of August 2020 when some organization incorporates, instead of September 2021 when the land swap happened.
So Judge, my first contention to all of that is, in order for us to need to put a witness on to explain why it can't be further delineated and narrowed, it has to be determined that it is insufficiently broad. And again, this is an indictment. It is about what the accusation is. I've explained to the court why we accused it the way we did.
No, you didn't.
Alleged it the way we did, which I don't think is even necessary. I mean, it is not an overbroad. We have to allege a pattern. Again, all of those cases regarding, and I haven't read the one that he provided earlier. I have not read that. But I did read a short blurb. The child-involved child crime cases, Judge, literally part of the rationale behind that is that a defendant charged with rape or incest, it's not permissible for the state to just generally allege sort of this pattern of conduct and that that's not fair. That is the exact opposite of what the law requires for us to allege. And
no, like, it's a very simple question. There's some stuff that happened in 2020 and there's some stuff that happened in 2021, and we want to know why the 2020 stuff is relevant if the thing, really started in 21. Like, this isn't about, she's just completely missing the point.
Prove RICO. RICO requires us to allege a time frame in which the conspiracy exists because we
but that time frame doesn't make sense.
Must allege the pattern of racketeering activity. As to that one case whose name I do not remember, I pulled it up, I didn't read it in full, but I can tell you.
Why would you admit that?
In the holding section, one of the things it said was it's not valid because the 43 predicate acts or the 43 separate acts there was no date given. That's the exact opposite of what we've got here. So we have a date range that we say in our indictment. I'm not saying what's going to happen at trial, but we have accused these defendants of participating and conspiring in this enterprise or while associated with this enterprise in RICO activity between these two dates, and then allege specific instances of overt act and predicate acts with specificity and dates. In that scenario, we don't get to put on a witness because they haven't satisfied the burden that we would need to narrow it. And so that's the state's position with regard to that. Now, moving back, and I understand why it was a little discombobulated when I started back in on the indictment. However, let me go back, Judge, and I was before the break talking about how the indictment alleges racketeering activity or a pattern of racketeering activity, and I started off by saying all we have to do is sufficiently allege a single incident of domestic terrorism.
She still doesn't understand the question, which is how does Liberto tie in to the conspiracy? She still fundamentally does not understand the topic of discussion.
To establish a pattern of racketeering.
The judge laid it out for her. He said, how do you tie in this specific defendant to that pattern of racketeering activity? Even, just assume the pattern of racketeering exists. How do you tie this defendant into it? And she's still talking about the pattern. That's not the point of the question. She's had an hour and a half of lunch for somebody to explain to her what the question is, and she still doesn't even get the question that's being asked.
Racketeering activity. In section 2 of our indictment, in paragraph 152 of count 1, we allege that Guy, on January 21st, 2023, Naja Geyer, Madeline Fiola, Emily Murphy, Francis Carroll, and Ivan Ferguson did join the night of rage in Atlanta and caused...
That's not the point. We're talking about Liberto.
...arson and property damage, and thereby committed the offense of domestic terrorism. However, going back to the Sanders case, Judge, which talked about compound crimes, conspiracy being a compound crime, that you can look to the other counts for the rest of the details to support your predicate act offense and whether they've been put on notice. And corresponding count 2 of the indictment further sets forth all of the elements of that exact same domestic terrorism. It relates back to it. It follows the language, same date, same individuals involved. So there and then, under the law, whether people think it should be enough or not, but under the law, we have alleged that as an overt act, these participants, these 4 on this date, participated in domestic terrorism, and then in count 2, as allowed by Sanders in a lot of other cases too, but Sanders in 2022, then we then supply the necessary factual specificity, or excuse me, alleged specifications or specificity to the domestic terrorism and how they committed it. So that's one. So right there, Judge, we've established a pattern of racketeering activity.
That's not the issue. I mean, it is, but not right now.
Then you get to, did we establish a pattern of racketeering activity under 1614.3.4a, which is the subsection that says at least 2 acts of racketeering activity in furtherance of 1 or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commission, or otherwise are interpreted by are interrelated by distinguishing characteristics and are not isolated incidents. And then it goes on to give you the time boundaries of when those can occur. Racketeering activity then gets defined. So what are incidents of racketeering activity? And this is where I was talking earlier. Racketeering activity includes 2 different things. One is the commission, attempt to commission, etc., of enumerated offenses, and it's like through 43. And it's not just 43 offenses, it's 43 categories of offenses. So, for example, assault under the chapter and article, and so it would be any of those assaults. But 43 categories of offenses. Or B, which is what I was talking to you earlier about the fact that if the court, the indictment can allege acts or threats involving felony arson and felony obstruction of justice. And so if we have then, within the entirety of this indictment, alleged either, we have already argued that we allege domestic terrorism, so we're done with pattern of racketeering activity. However, if the court deems otherwise, then have we done it through one of those 43 categorical crimes under A, which would have to include all of the elements of those underlying offenses because they are, in fact, the commission of an offense. Or under B,
I think this is just creating record. That's what the judge is doing. Liberato's case is getting tossed.
Which is allegations of acts or threats involving the arson and the felony obstruction. So, and I quoted that case to you already, Judge, so we won't reiterate. So going to the specifics, and I'm going to start with A, which is the racketeering activity that is in and of itself a crime. And the state asserts to the court that the indictment in its entirety sets out multiple allegations that are sufficient to establish an assault. And this goes back to the beginning, Judge. I quoted.
Yeah, exactly, Turner. I think that's right.
I think it's still Sanders. Yes, Sanders v. State, where it says the indictment must, one of the 3 ways is if the indictment alleges elsewhere facts showing how the compound offense was committed. So one of those 3 ways, either in count 1, setting out all the elements, and the elements are all set out in in the entirety of the indictment, or we've alleged sufficient facts to establish the elements essentially of the compound crime. So starting with assault, the state would assert to the court that the indictment in its recitation of 225 overt acts that specifically the indictment says include racketeering activities, that we have alleged assault in paragraph 72, in which it gives a certain date, says specific individuals, Abigail Stapyak, Philip Flagg, Madeline Kodak, Quartermont.
I'll just show you that real quick. I'm sure it won't matter. No, not you. That's the wrong window. This one. Stapyak, Flagg, Kodak, Quartermont, Hoyt Lang, Anna Lee, and 2 unindicted co-conspirators did throw Molotov cocktails and glass bottles at police officers. This is an overt act in furtherance of the conspiracy. That is all that says.
Mariana Hoyt Lang and Anna Gypsy Lee and 2 unindicted co-conspirators did throw Molotov cocktails and glass bottles at police officers. 2, the state asserts that we have alleged an aggravated assault in paragraph 110. On November 8, 2022, Abigail Stapyak did provide information to a masked unknown individual that held Richard Porter, a metal scrapper, at gunpoint in Increasement Park, thus committing aggravated assault against Richard Porter. The third example of an assault is paragraph 116 on...
She provided information.
Yeah, I need to show you guys this one. This is bizarre. I think this must be a typo or something. 110, Abigail Stapyak did provide information to a masked unknown individual that held Richard Porter, a metal scrapper, at gunpoint in Entrenchment Creek Park, thus committing an aggravated assault against Richard Porter. What? Did provide information to a masked unknown individual that held Richard Porter, a metal scrapper, at gunpoint. Like, this isn't even fun dumb.
Against Richard Porter. The third example of an assault is paragraph 116 on...
She provided information.
Information to the person, yes.
What time of day it was? What kind of information? She provided information to somebody committing a crime.
To somebody who held him at gunpoint, yes.
Okay. And what kind of information was that?
It's not alleged in the indictment.
That's not what he asked you.
I mean, I can tell you that, and it's in the discovery, but it's not alleged.
Answer the question.
In the indictment.
So how is Ms. Stapyak supposed to look at number 110 and go, I'm not prepared for that. I provided information.
I mean, I think she has to know what she needs to defend against, and I think it puts her on notice that what she needs to defend against. And
information.
It doesn't say to whom she provided the information. It doesn't say what the information is. It doesn't say... I mean, this sounds... The way it's written, it sounds like she provided information after the assault. I mean... Like, what...
With the information provided to an unknown individual.
It could be more specific. I'm not arguing
it could be more specific
with you about that. Our contention is that it is sufficient to put them on notice and sufficient to plead a predicate act.
We know that's your contention.
You allege it as an overt act, not a predicate act.
Well, it's both, and it's alleged as both. It's, I mean, it...
No, this is an overt act in furtherance of conspiracy.
Yes, but at the heading...
Thus committing an aggravated assault?
Yes, but at the forefront of those 200...
I'm going to put this up again just because it's such a weird... Abigail did provide information to a masked, unknown individual that held Richard Porter, a metal scrapper, at gunpoint in Entrenchment Creek Park, thus committing an aggravated assault. So how you kind of need to know what the information is, because otherwise, how do you know that, you know, the information constitutes a... How does providing the information give rise to an ag assault, you know? Like, it's just bizarre. It's like, I'm not arguing that it's wrong. It is, but it's more like I just don't understand what it's even trying to say.
25 paragraphs, in Part 2, it says, the defendant committed overt acts to affect the object of the conspiracy, which include acts of racketeering activity as described below.
So they're all racketeering activities.
Then you're going back to paragraph B. Is that where you are?
Part 2, no, it's the beginning. Excuse me, Judge. Let me pull up the indictment real quick so I can make sure that I'm directing you to the right portion. Do you have the indictment pulled up?
I've got it pulled up. Part 2 of the indictment?
It should be right above the beginning of the recitation of the 225. This is Part 2.
Page 49.
Thank you.
The defendants committed overt acts to affect the object of the conspiracy, which includes sets of racketeering activity.
It's this part right here.
As described below. Acts of racketeering activity as described below.
Yes.
It actually doesn't make sense.
Okay.
And I think you're getting to something that will be covered in a later argument.
Don't tell judges what they're getting to. They know what they're thinking. Just answer their questions.
So, Judge, then we move to, I think I left off with paragraph 116 on December 13th, 2022. And I'm going to just kind of abbreviate instead of exactly quoting, but Carroll, Tilbury, Olson, all named defendants in this indictment, did throw rocks, a bottle, shoot fireworks at firefighters and EMTs. Paragraph 121 is another simple assault. December 13th, 2022, Serena Hotel.
Wait. She said 121 is a simple assault. 121 says Serena Hertel did cut a rope in an attempt to cause an arborist to fall during climbing. This is an overt act in furtherance of the conspiracy. Okay.
Did cut a rope in an attempt to cause an arborist to fall during climbing. This is an overt act in furtherance of the conspiracy, which is at the end of every one of them because it's required for us to allege that they overt acts are in furtherance. Fifth incident of assault or aggravated assault alleged in the indictment is paragraph 124. December 14th, 2022, Ariel Ebaugh did approach the cab law enforcement with a rifle, knives, and a pistol in a threatening manner in an attempt to intimidate the officers, thus committing an aggravated assault against the cab law enforcement. So right there, based on that, our allegation or our assertion to the court is that first and foremost, we established domestic terrorism. We supplied the necessary elements and details in count 2, which is completely permissible under the law of the state, and because it's a compound crime, and that we have also in these predicate acts set forth the necessary facts to allege either assault or aggravated assault. Then judge number 27, or the 27th, because it's not number 27, it's like XXLL, whatever it may be. The 27th category or list of offenses under 5A that can be alleged as racketeering activity is influencing a witness. And the elements of that are...
Again, she just doesn't understand what's going on. We're not talking about whether you allege the crime. It's about, did you allege it with respect to a specific defendant?
It shall be unlawful for any person knowingly to use intimidation, physical force, or threats to persuade another person by means of corruption or attempt to do so, with the intent, B, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And that's obviously not the entire statute, Judge. I have sort of culled it down to include only the portions of the statute that we assert are relevant to our indictment. And so the state asserts to the court that the indictment contains 41 separate allegations of co-conspirators using threats with the intent to cause and induce construction officials to withhold records, documents, or testimony in official proceeding. Those paragraphs are 5 and 6, 8 through 11,
Okay, I can't.
13 through 15, 17 through 24, 125, 127, 128, 130, and 158 through 164. Each element necessary to prove the statute that I read to you earlier. I know that there was an argument from somebody, I'll just go ahead and address it, that we did not allege that there was, and there in fact wasn't a pending proceeding, and I'll provide the statute to you, but the statute just directly states that there is no burden to prove, much less plead, that there is an ongoing pending proceeding. So based on that, we allege those things, Judge, according to the state, we have alleged domestic terrorism, so check off pattern of activity being alleged, pattern of racketeering activity, alleged.
She's still talking.
So those are our 5 through offenses in which we assert that we have met the burden through Sanders and the Sanders standard. I don't remember if it's Sanders would say. The Sanders standard that all of the necessary elements that are provided to the defense through either recitation of the statutory language, or recitation of facts that would support the elements of the offense or prove the elements of the offense. However, we're not limited to those 5A offenses because of subsection 5B. And again, Georgia rejects that notion of an obstruction is in Georgia State Patrol head.
She's been saying the same thing for hours. She's just been saying that she's alleged the crime, but the issue is with respect to specific defendants. So she keeps reiterating why she's alleged the crime.
Orders, and that is an act or a legend involving a published bank, commit threats,
93.
and intimidate witnesses. That's our allegation.
I'm looking at 1610-93, influencing witnesses. The person who, with intent to deter a witness from testifying freely, fully, and truthfully to any matter pending in any court, in any administrative proceeding, or before a grand jury, communicates directly or indirectly to such witness any threat of injury or damage to the person, property, or employment of the witness, or to the person, property, or employment of any relative or associate of the witness, or who offers or delivers any benefit, reward. The first part was the stick, now they're getting to the carrot part of it. Okay. And you're saying publishing this stuff was an indirect communication.
Judge, I'm saying that it fits under, if you'll give me 2 seconds, 93.
1,
There it is.
2.
That it fits under,
That was bad time.
it shall be unlawful for any person to knowingly use intimidation, physical force, or threats to persuade another person by means of corruption or to attempt to do so, or to engage in misleading conduct towards another person with the intent to influence, delay, or prevent the testimony of the person in an official proceeding. B, and this is what we've alleged, to cause or induce any person to withhold testimony or a record, document, or other object from an official proceeding. And official proceeding is not just is defined, and it is not limited to court cases. I'm trying to find, there it is. In 3A, it includes hearing or trial conducted by the court of the state or its okay. Okay, sorry. I'll just read. Any hearing or trial conducted by a court of the state or its political subdivisions, a grand jury, or an agency of the executive, legislative, or judicial branches of government of this state or its political subdivisions and authorities. So it does not have to be a court case. If there is a hearing in an administrative hearing that falls within those branches of government and that type of hearing as defined in that statute, and somebody does something and threatens with the requisite intent And that's what we've alleged in this.
So what's the hearing?
Okay.
So we've alleged that's one of the ways, but that they use these threats to intimidate and influence construction officials from doing the elements of the crime. I'm not going to read it all again.
She prevented the construction officials from doing the element of the crime? That sounds like a good thing. That's law enforcement, really.
To prevent them from providing documents, etc., in an official proceeding. Now, let's see, where was it? All right. Yes, acts involving arson. Paragraph 152, on or about January 21st, 2023, Geyer, Fiola, Murphy, Carroll, and Ferguson, and this is that paragraph we read earlier, did join the Night of Rage, and caused arson and property damage, and thereby committed the offense of domestic terrorism. So, at a minimum, that is not only directing them to the count 2, but it is also an act involving arson. Paragraph 153, on or about January 21st of 2023, Ivan Ferguson and Naja Geyer rode together in the Night of Rage inside a truck with a gas can and camping gear and a climbing gear.
I don't know what question she's trying to address.
I withdraw that, Judge. I don't think it's clear enough as I read it. I don't think that's clearly enough that it is involving. Now, it is later charged as part of the arson, and so you can argue that it is that paragraph in conjunction with count 2 puts them on notice that it is a act involving arson. However, I will go with count 2 as a definite way of putting them on notice and providing them with all the necessary details that they've been charged with an act involving arson.
Is not 153 and 154 the exact same sentence?
Let me check, Judge.
Let me check, Judge. She said 53 and 54? Oh, this is really funny, actually. Let me slide this over here. There we go. Okay. On or about January 21st, 2023, Ivan Ferguson and Nadia Geyer rode together to the Night of Rage in Atlanta. Inside of the truck was a gas can, camping gear, and climbing gear. This is an overt act in furtherance of the conspiracy. 154. On or about January 21st, 2023, Ivan Ferguson and Nadia Geyer rode together to the Night of Rage in Atlanta. Inside of the truck was a gas can, camping gear, and climbing gear. This is an overt act in furtherance of the conspiracy. That's really funny.
Yes, I do believe there's one that's repeated. I do believe there's a duplicate, Judge. Let me check, though, if you don't mind. Let me have just a moment.
The judge is telling you that it's duplicated. He's just being polite about it.
153. I think that's correct. I think I noticed that.
No, you didn't. You did not.
They're duplicative, Judge. So we can agree that one of those would be direct or struck.
What do you mean you can't agree that? He doesn't care if you agree. He's going to do it.
All right. And then, Judge, in paragraph 155...
I don't even know what she's arguing. Like, in theory, what she's arguing. I certainly don't know what she's actually arguing, but I don't know what she's trying to argue.
On the same day, Carroll is alleged to possess a lighter and accelerant while attempting to break into 191 Peachtree Street in Atlanta and did commit the offense of domestic terrorism, referring to count 2, of course, where all the rest of the details. However, that plus count 2 definitely puts him on notice because count 2 explains that he was doing so in pursuit or while attempting to commit an arson. So that puts him on notice that he is thereby charged with the predicate act involving arson. Number 6, in 2015, an organized mob and succeed in overwhelming police force, thereby in that over.
Okay.
No, sir.
Domestic
terrorism. And then it also has the overt act language.
The arson and domestic terrorism that happened back in January?
No.
Okay.
No, sir. It's a separate date. It's a separate incident. This is well, you don't need me to get into all the facts. This was the March 5th incident where they burned a bunch of stuff and set things on fire. Anyway, so that specific allegation definitely 24 separate times against 24 separate defendants alleges that each one of those 24 co-conspirators, as alleged in the indictment, committed acts involving arson. So that's 29, I believe, Judge, and I'm not the best at math, but 29 acts involving arson have been alleged. Then we get to acts or threats involving felony obstruction. We've got 27 of those alleged, Judge.
I don't even know if
that's paragraphs 119 through 121, and that's December 13th. Did issue a call to action on Instagram to prevent felony obstruction at every house. 121, the same person. And then in the other ones that on 9 did act of some of them are in fact 29 of influencing a witness, 3 allegations of 50 domestic terrorism. So you've got conduct terrorism. As far as court's time, because many wants to prosecute the state of really support that. Thank you.
God.
Do you want to follow that back up? It's y'all's motion. I'm going to take that as a yes.
All right. A lot of issues that she raised, some of which, as I told you before, we got no briefing from the prosecution before this hearing today. So none of the cases they've cited, nothing that they've cited here today was ever previewed with the defense over the last 2 years. So it makes it a little difficult to reply to some of these. But I'm going to do the best I can. First of all, with regard to the issue of the impropriety of the introductory language, the 25 pages of the, as you put it, the Aleppo allegations, this is not a case like Mr. Fowler referred to in the Second Circuit case involving a prosecution of the Genovese crime family. Of course there are going to be allegations about the history of the Genovese crime family, just like there can be allegations about the history of the actual enterprise in this case, as opposed to going back literally hundreds of years with allegations about the history of anarchism and violent anarchism. There's a world of difference between alleging the background of the Genovese crime family in a Genovese crime family prosecution and allegations about the history of the philosophy of anarchism in the world. Second of all, the allegations in our case include all kinds of allegations from taped interviews of people who are masked and who make allegations that are never identified. And we have no idea who these people are. People making violent allegations, violent suggestions, supposedly, to members of the enterprise here. A clear violation of the Confrontation Clause, no matter how you dress it up. They can, whatever Mr. Fowler claims about where they derive this information from, I don't know, I have no idea, because it doesn't allege where they found it or gathered it. So the idea that they can present to the jury, either in the indictment or even in evidence, a masked person reading a script saying we should kill more policemen would never be tolerated in an American courtroom. So, Mr. Fowler's closing remarks where he says we think this does go to the jury. The entire indictment goes to the jury, including this language. And these allegations by, unidentified people is a clear violation of the Confrontation Clause and due process. With regard to the suggestion that we should just simply strike it, that we could use the vehicle of a motion to strike surplusage, that is actually not done very often in Georgia. It's done frequently, much more frequently in federal court, but in Georgia it tends to be done with as an errant word or an alias that didn't, we're going to call some guy, Murdering Joe or something. We can strike that kind of surplusage. We're talking about striking 25 pages of this indictment. That's what we're talking about, is the only remedy which we believe is more akin to a special demurrer, as opposed to, dressing up the indictment a little bit or cleaning it up a little bit through a motion for surplusage. So we stand on the position that it is a remedy, that the remedy we seek, which is dismissal of the entire indictment, go to a grand jury without polluting the grand jury with this information and inducing the grand jury. Because of these masked people, you can assume that all these defendants out here are murderers, and they all advocate for murder and killing policemen, which is what the introductory language suggests with these masked people who are giving speeches. The only possible remedy the only reasonable remedy is to dismiss the indictment, grant the special demurrer with regard to that, and let the grand jury return an indictment which is more befitting a courtroom in this county and in this state. With regard to the demurrers, and I'll start with where Ms. Dixon finished, which was these allegations dealing with intimidation of witnesses. If you look at the overt acts that we're dealing with here, time and time again, they talk about my clients, as well as many of the other clients, engaging in some kind of conduct to effect an official proceeding. Ms. Dixon's correct. It doesn't have to be a pending proceeding, but it has to be an official proceeding. And they've never identified, nowhere in this indictment does it allege what official proceeding was supposedly going to be impacted. And there's nothing in either the federal intimidation statutes, the obstruction statutes, or the state statutes that say you can just allege an official proceeding and we'll just let the jury decide. Because we sure have no clue what they're talking about. We have no clue what the prosecution's intending to present before the grand jury, before the trial jury, as to what official proceeding could possibly be envisioned by the defendants who were engaged in this conduct. And given their argument today, I will give you a case, a recent case. It's not in my case. The case is State versus Eastman. This is the Trump case, in which we argued to Judge McAfee exactly this issue, that there was a solicitation to the legislature. I don't know if you've ever read the Trump indictment, but the defendants are alleged to have solicited legislators to violate the Constitution by uncertifying the election. That's the allegation against the Trump co-conspirators. And we argued to Judge McAfee that the indictment was defective because it didn't say what part of the Constitution do you claim we were violating. And he agreed, and the Georgia Court of Appeals agreed. And the case is State versus Eastman. The citation is 374 Georgia Appeals 484 this year. That's Judge McAfee in the trial court last year and the Georgia Court of Appeals this year. 374 Georgia Appeals 484, granting a special demurrer, dismissing all those counts of the indictment. There were many counts of the indictment dismissed. Agreeing with our argument that you've got to be specific when you're talking about, what part of the Constitution you were soliciting the legislators to violate. Clearly analogous to the argument we're making here is you have to tell us what official proceeding you're claiming we were trying to obstruct. It doesn't have to be pending, it could be envisioned, but at least we have to have been thinking of an official proceeding, and they have to identify what kind of official proceeding and what specifically official proceeding we were envisioning. With regard to, Mr. Garland's going to be arguing either next, or I'm not quite sure what the order of proof is going to be here, but he's going through a lot of the special demurs that surely apply to my three defendants. He's representing someone else. I mean, it's just count after count after count where we're having to guess what the prosecution is going to try to prove, which is exactly what the office of a special demur is. And the prosecution is wrong when they say, you already contested this. Just look at the discovery, you can find out. Federal courts, sometimes they allow that. They allow it with a bill of particulars. We don't have bill of particulars in Fulton County Superior Court or in the courts of Georgia. They have to allege the facts that are needed. The facts that are needed, not just the law that is violated. And the Jackson case that we put in our brief, 301 Georgia 137, in our brief, explains, the Georgia Supreme Court explains that a special demur can demand facts that allow us to prepare a defense. Now, I'll go back to the Scenes blog allegations again. And Mr. Fowler says, oh, it's as clear as can be. We've identified every fact you could possibly want to know. You authored something, and then describes the supposed statement that we authored, and it ended up on some blog site somewhere. Dozens of counts, many of them dealing with the official proceeding claim as well. And yet they never say how we supposedly authored it or who authored it. Because each of those counts says some undefined number of unindicted co-conspirators and Marlon Cass and Adele McClain and Savannah Patterson all authored something that ended on a blog post. We have no idea what the actual allegation is. We can find the blog post. It doesn't have anybody's name on it. We don't know who the unindicted co-conspirators are. Apparently they don't either. We don't even know categorically who the unindicted co-conspirators are. There's no defense we can do. We could have started the trial the day after the indictment was returned, because we knew as much then as we know today. And the prosecution also says, you can find it in the discovery. You can't find it in the discovery. I went to Mr. Fowler's office. Me and Mr. McDermott went to Mr. Fowler's office. Would you tell us how you have facts that show that either Cass or McClain or Patterson authored these things in the Scenes blog? I told you this morning. They gave us one piece of paper that has the Atlanta Solidarity Fund and Scenes blog on the same page. We don't even know who authored that page or what it was. It was from what they call a zine. But nobody knows who authored those or who it was a fundraiser. We have no idea that has anything to do at all with proof that we authored it. And the Jackson case says where you need facts to prepare a defense, facts should be supplied. And just saying you authored it without giving us any information whatsoever requires that those predicate acts be dismissed, that a special demur be granted. And I was going to go through a number of these overt acts, but I think Mr. Garland's going to do that and shows all the special demurs that are needed. So if I could just defer to him. Plus, most of them have nothing to do with these four defendants. So it's,
you might fight that another day then.
Some of them, and I'm concerned that I may not understand the proper protocol here. I mean, there are many, many issues dealing with our three clients. I say my law firm's three clients that have nothing to do with them. And I'm sure you don't want to hear about, for example, the motion to suppress is still pending. It has nothing to do with these four people. It's been sitting there for, 2 years now. We have the whole filter team issues that we're working through at least, and close, but not done, resolving. But just dealing with the demur, if I can. The other thing I would point out, I want to talk just briefly about the Dorsey case. This is Sheriff Dorsey. You remember Sheriff Dorsey was alleged to have assassinated or arranged for the assassination of Derwin Brown in DeKalb County. I represented Sheriff Dorsey, unfortunately, because I lost that case that Ms. Dixon is talking a lot about. And it does have troubling language about the definition.
That's always a flex when the lawyer can say, oh yeah, that was actually my case, when the other person cited it.
My definition is troubling language about the definition of a racketeering act. the structure of the statute is, and Ms. Dixon talked about this a little bit, is there's a list of 43 specific generic crimes in Georgia, including homicides, everything in chapter 1651, various sex offenses, 16.6. If you look at section 5 of 1614, whatever, it's 30, Georgia code sections. And then if you look at 5B, it says any crime in any state involving murder, arson, and the whole list. It is clear from the legislation that what the intention was to bring in the laws of all 50 states, because RICO allows you to prosecute for crimes that occurred outside the venue. So first they identify all the Georgia crimes, including murder, including arson, including intimidating witnesses. That's all in A. And then it says, and in any state, crimes involving arson, murder, and intimidation. Because they're trying to bring in reality, another 49 states' laws in Section B.
Don't forget the territories.
And D.C. And
Guam.
Huh?
Guam.
That's right. Greenland.
Right.
No?
Not yet.
Not yet. So, but listen, I'm gonna be honest. The Supreme Court didn't agree with this, and the Supreme Court agreed with Ms. Dixon. And again, I suppose we're going to have to honor that here. They did say when the statute said "and any state," even though it is abundantly clear they're trying to bring in 49 states.
It meant Georgia too.
We're one of the 50.
Yep.
So the question is how to limit Dorsey somehow to make sense. Because why would you say you have to prove a predicate act, murder, arson, and then say, or any act involving murder? It's completely duplicative. There's no reason to have had Section A at all if you're going to say any act involving murder. It doesn't say any overt act in B. And in Dorsey, they never defined what they meant by an act involving. We know what the legislature meant. It meant the crimes in Maryland involving murder, the crimes in Kentucky involving murder, the crimes in South Carolina and Alabama, because they didn't want to have to go through every code section of every state. So, but the point is that has nothing to do with the demurs that we've filed. Because none of my clients are charged with, my clients, my law firm's clients, none of them are alleged to have violated an act involving murder or an act involving any of these other code sections that they're alleging. Nor do the predicate acts say that that's what they're relying on, a 5B allegation. As she said, calls them 5B claims. None of them say that. We're just left to guess. What is the predicate? What are we defending here?
Does the indictment have to delineate between 5A and 5B? I mean,
I would think so. They have to say they can't just. They don't give us many facts, and then they don't give us the appropriate code section. That's what Jackson says. Jackson even says you shouldn't even rely just on code section. It should be code section plus element plus facts. And if it's obvious, and sometimes it is obvious, like in Sanders with some of the counts were thrown out in Sanders. I mean, Sanders has some counts that survived the Supreme Court, and other counts, I think Judge Bethel wrote the decision, other counts where he said, you allege they violated the Controlled Substances Act. He didn't say what drug. Well, I think under their analysis here today, you don't really have to do that. Just say VGCSA. But Judge Bethel said, no, you got to be precise. You got to be precise. Exactly what drug. And that's for a solicitation count, where it's the predicate offense for a solicitation count. Were you with me? The defendant asked someone else to sell him some methamphetamines, and the indictment said you solicited someone to sell drugs. And Bethel said, in violation of VGCSA. And Justice Bethel said, that's not enough. You got to identify the specific drug. Well, that's like the official proceeding in these counts. You got to identify the official proceeding. You have to be precise so we can at least prepare a defense. I'm back to surplusage for 1 second. Mr. Fowler says one of the reasons we can put it in is because it came out of their own language or their own mouths, the defendants. I seriously doubt that. I seriously doubt the accuracy of what he said there, not intentionally, but is he claiming that they have one of the defendants reciting 25 pages worth of the history of anarchism somewhere? We certainly haven't seen that in the discovery. And so I think what he's doing is he's saying we've got these masked people talking. So we're not going to tell you who said it. We're not going to tell the jury who said it. Just someone wearing a mask said, you know, during the night of rage or day of rage, we ought to kill some cops. And says, well, that's why it's in the indictment, because some masked person said it. And then he said, well, maybe it came out of books or articles. Well, let me remind him of the First Amendment and you know, the Anarchist Cookbook. A lot of people have got a copy of the Anarchist Cookbook. I bet you've got a copy of the Anarchist Cookbook in your library. But nobody would say that you're making bombs, you know, or that you believe in bomb making, or that you advocate bomb making.
The judge of having
And
Anarchist
we all have books in our library that we don't actually advocate for. I mean, criminal defense lawyers have all kinds of books in their libraries about the crimes that we defend against, our clients who were charged, you know, and you may remember from our motion to suppress the types of materials they seized from our client's house. The voluminous amount of books and magazines and pamphlets. Some of them were in fact written at the beginning of the century, and they're claiming they're going to use that in our trial. So strike the surplus or not, they plan to put it in anyways because it was in Marlin's library. And we quote 100 cases to you saying you can't put the Anarchist Cookbook in evidence. It's the same as, you know, rap music cases.
Oh boy.
So I'm going to defer to Mr. Bond if I can, with all due respect to these four folks. When their special demurrer gets raised, I think he's been invited to deal with those facts. But we maintain general demurrer should be granted in this case because of the various flaws with the indictment. Can you imagine, can I just finish with this? Can you imagine trying to instruct the jury consistent with everything that Ms. Nixon just said for the last 2 or 3 hours? Can you imagine trying to explain to a jury the way this indictment is framed? The intricacies of the verdict, either guilty or not guilty on count one. How are they going to do that with this indictment?
I would look forward to reading the proposed jury charges provided by the parties.
Well, we have tried actually to start working on that. It is impossible. It is impossible. Okay? I mean, you've read the indictment, right? You've read the motions, you've read the demurs, you certainly know the statute. Can you imagine trying to explain to a jury how, take my clients who've never set foot in the forest, who paid for people, who arranged for the payment they didn't pay, arranged for payment for people for hot dogs, veggie dogs actually, that is or is not an overt act that you can use to hold them responsible, hold my clients responsible because they're paying for food. You about to ask me a question? Or about to be frustrated?
No. I was just supposed to make a Godfather reference. Marlon Brando never pulled the trigger. Marlon Brando never went on the scene.
Yeah. Well, we don't know about that, but But
that's kind of what RICO was originally designed for. Was it not?
Well, it wasn't necessarily for Marlon Brando. It was for racketeering. It was for organized crime families who have a vast array of crimes being committed by a vast array of people in various jurisdictions.
And yes. How to get those people that manage to keep their hands clean.
Oh, I don't know about that. It's always been that the ringleader is certainly subject to being prosecuted. There's nothing about RICO that makes that unusual. There's nothing about RICO that says go after the kingpin. I mean, it's the same level of proof as before RICO was enacted. But, I'm sorry, we're off track a little bit. The fact that my clients didn't go to the forest is certainly an issue here. They're not charged with with trespassing. They're not charged with.
Michael didn't get in the boat with Fredo.
Say it again.
Michael didn't get in the boat with Fredo.
Put the hit out.
I assume there's cement shoes somewhere in that, right?
Never seen The Godfather?
Many times. All right, all right.
Fredo doesn't make it out of the boat. Let's just leave it that way.
Okay. Thank you.
Okay, 1:30, where are we? We were in this,
I think I need to stop now, unfortunately. I wish I could keep going, but it's getting to be nighttime, and I have to take care of a few things. I think I'm going to try to maybe do live coverage tomorrow. Maybe not, though, depending on how much work I have to do. Unfortunately, I'll maybe try to get caught up on, or try to finish today's motions hearing. I'm actually not sure if it's live tomorrow. I think it's supposed to be. I know it was originally scheduled just for today. But yeah, I need to go take care of the puppy, do some other stuff. But yeah, we'll definitely make it through all of this at some point. No question about that. Because this is special. I do imagine that at least the Liberto. Oh, that's a good question, Kat. Let me see.
About the allegations in part 1 of the details overt act and felony obstruction. It doesn't have.
All right, ladies and gentlemen, it is 4:45. See you tomorrow.
We have our answer. They will be going live tomorrow. So yeah, I think I don't know. I probably won't be able to do it live. He talks about movies he checked out. Yeah, probably. I think he made up his mind with respect to Liberto. But yeah, have a good night, everybody. And yeah, I assume I'll be live tomorrow. I'll let you know. Oh, and hit the like button. Trenton will be proud of me if I say that. So you should do that. Okay. All right, everybody. Have a good night. Okay, yeah. Night, everybody.